number 23, Division L of the District Court, County. We'll call up 21 CR 2800, 21 CR 2806. The parties and counsel are present. All right, when we broke yesterday, it was presumably time for motions after the close of the people's case in chief on behalf of the defendants.
Yes, ma'am.
And I'm assuming that you got a copy of the memorandum, I suppose, that was filed.
Judge, I saw it was filed. I got here early because my internet at home was down and I couldn't get onto the court's internet. So I have not had a chance to review what the people filed at all. I did see they filed a memorandum of law though. So I will make my argument, and if there's additional responses the court needs, I can respond to it.
I apologize. I did also need so I'm sorry.
It's been that kind of long night.
2. All right, on behalf of Mr. Cooper.
Yes, Your Honor. And I would just tell the court, Mr. Pello is going to be in and out. He's meeting witnesses as they come in. So on behalf of Mr. Cooper, Judge, at this time, we're asking the court to enter a judgment of acquittal on count 13, on the sentence enhancer count 18.
Hold on. Need to find what I did with my copy of the. Okay, I'm ready.
And the reason for these, Judge, are that these allege that a deadly weapon was used, either in the specific elements of the assault charge or in the sentence enhancer charge. As the court was alluding to yesterday, but we would start with looking at the fact that what is at issue is what constitutes a weapon. And I would, in Saleh 45 P 3rd 1272, what really was at issue in that case was not whether it was a weapon, but whether the weapon caused the injury. So the argument there was as to the causal connection. But then if you look through the history of the cases, there's a clear line of cases dealing with the definition of what constitutes a weapon or a deadly weapon. In People v. Stewart, 55 P 3rd 107, the court made clear that objects that are not delineated as a per se deadly weapon, such as a firearm or a knife that's been interpreted to be over 3.5 inches, must be used or intended to be used as a weapon. There's a second prong to the test. It must be capable of causing serious bodily injury. What's relevant in this argument from Mr. Cooper's position is prong 1. In People v. Gross, 830 P 2nd 933, Colorado 92, the court wrestled with, again, what constitutes a weapon, and therein what they're wrestling with was a screwdriver. And the court was talking about when you fall in this kind of not per se, not delineated section, the court says an essential component is the intent to use the instrument as a weapon. In People v. APE 20 P 3rd 1179, again, the court reaffirms that, and that's in 2001, and the court said any not per se weapon requires proof of intent, and that the catch-all provisions must be interpreted with this in mind. The test is not whether the defendant used as a deadly weapon, but whether the defendant intended use as a weapon. In that case, the court then went on to say appearance of an object alone can't show intent, and that the prosecution must prove that the defendant intended to use the object, herein ketamine, as a weapon. In People v. Esparza-Trado, 282 P 3rd 471, the court made clear that the fact that an object is capable of causing serious bodily injury is not alone enough. It must be deployed as a weapon. Therefore, the item must be used in connection with assaultive conduct directed towards an intended opponent or adversary. There's been absolutely no evidence of that here at all. Also recognizing in Esparza-Trado, if we interpreted the statute more broadly, you're going to fall into an equal protection clause trap because somebody would be unaware that their conduct could violate the law. In People v. Buell, 442nd, P. 3rd, 961, again, the court says a deadly weapon is any other weapon not delineated and sets forth a two-part test. Did the defendant intend to use the object as a weapon? And was the object capable of causing serious bodily injury? Again, at issue in this case, we're dealing with prong one. What is not relevant is the ultimate result of the object. So kind of the opposite of the dull knife case, if you will. But equally relevant is it doesn't matter what the outcome is. So whether somebody doesn't get injured or whether somebody dies, what matters is what the intended use of the object was. In People v. Lee, 476 P. 3rd, 351, the court says, defines a weapon, citing back to Esparza-Trado, as an instrument of offensive or defensive combat, something to fight with, a club, a sword, a gun, a grenade, used in destroying, defeating, or physically injuring an enemy. If we now expand the use of ketamine when being administered by a paramedic following their protocol to constitute a deadly weapon because the argument by the people is that it caused the death, we ignore what the intent component is. There has been no testimony that anybody ever said Mr. Cooper or Mr. Lieutenant Cichuniec intended to use this as a weapon. I know when we left, the court had talked about some examples of a taser or handcuffs, and I think those are good examples because, again, if an officer, a law enforcement officer, uses a taser, which is by definition a less lethal form, or a beanbag gun as a less lethal, but somebody ends up with serious bodily injury or death, you would be having people never on notice that by using something in the way that they were taught and designed to use it, even when there's an untoward result, that it would be a weapon. A different example would be, you know, Judge, if Mr. Cooper made for his child a peanut stir fry, and he put peanuts in the stir fry dish, and he had no idea his child had an allergic reaction. There's no question he was making a dinner and serving his child food, but his child had a allergic reaction to peanuts. To say that he used the peanut as a deadly weapon, it doesn't comport. And most critically, in this case, any medication, Tylenol, ibuprofen, anything could have an untoward result. And the medical providers would never be on notice that by virtue of the fact that they simply administered a medication, they could be charged with using it as a deadly weapon when there is no intent that that was what they were trying to do. I think the case law has been very clear in saying if the legislature did not delineate it, such as a gun or a knife over 3.5 inches, that there is a requirement that you have to show intent to use it as a weapon. We've seen that with automobiles. We've seen that with hands and feet. I think other examples would be golf clubs, things of that nature. But in the manner that was present, and even in all the light most favorable to the people, the argument has been undisputedly the paramedics administered ketamine. But there has been absolutely no evidence that it was done to be intended to be used as a weapon. There's no evidence that anybody perceived Mr. McClain as somebody that needed to destroy or defeat, or as the enemy. There has been no evidence that this was something used in the form of combat or in the form of trying to fight with him in an assaultive nature. This is just not what the legislature or the court or the appellate courts have deemed for what constitutes a weapon, and where there's been no showing of any intent to use the object as the weapon, we believe that those counts have to fall. So therefore, on behalf of Mr. Cooper, we're moving to dismiss the 2 counts that require proof of a deadly weapon. Thank you, Your Honor.
Thank you. On behalf of Mr. Cichuniec.
Thank you, Your Honor. Your Honor, the counts, the concomitant counts against defendant Cichuniec are identical to those that were referenced by counsel for defendant Cooper. We are moving for judgment of acquittal on counts 24 and 29 of the indictment, which are identical to the charges against Mr. Cooper at 13 and 18. I would further reiterate and join, and without repeating the arguments that were made by Ms. Bagan, I agree that the point of it all is whether or not the object at issue was used with the intent to use it as a weapon. And I think that the clearest statement of law that is put forth by the court in that regard is from Esparza-Trado, 282 P3rd 471 at page 476, where the court in no uncertain terms says, to be a deadly weapon, an object must be used in connection with assaultive conduct directed toward an intended opponent or adversary. And I would also point out that there has been no subsequent law undermining that frank statement of the law. And in fact, Esparza-Trado, rehearing was denied of Esparza-Trado by the Court of Appeals, and certiorari was denied by the Supreme Court in that case. So that is the state of the law as it stands today. And as was pointed out by Ms. Bagan, what the court was struggling with was the definition of weapon under the 2-pronged test. And just as there has been no evidence that the ketamine was utilized in this circumstance as a deadly weapon, there was no intent by defendant Cichuniec to utilize it as a deadly weapon or to provide ketamine to Mr. Cooper for the purposes of utilizing it as a deadly weapon. And in the absence of intent, charges 24 and 29 of the indictment must be dismissed against Mr. Cichuniec. And if the court has any questions.
Yes.
Very well, on behalf of the people. And I did get in early this morning and have the opportunity to review the P203 memorandum of law.
Your Honor, based on what counsel started with only a certain specific counts, I want to know for the record, are they waiving argument towards the other counts? Are we only addressing those specific counts, or does the court want me to make a record on all the counts?
I suppose you can make whatever record you'd like.
I understand that. All right, well, I'm just going to make the record, Judge, for all the counts, so the record's clear.
Okay.
For all the counts, Judge, the essentially first 3 elements are the same, that it's the defendant in the state of Colorado, Adams County, out and about the dates of August 24th, 2019 through August 27th, 2019. And if it pleases the court, I'm going to just, for all the counts, direct what the elements are, the facts are towards those elements, and then I will go count by count so that the record is very clear, but I don't want to have to repeat myself for the court. So it is clear in this case, Judge, that it is the defendants. And of course, we have Mr. Robinette, Mr. DeJesus, and Mr. Bradley who all ID'd the defendants in open court as people that were present on the scene that evening. We also have their interviews with Detective Ingui, where the jury saw who they were. We also have the body-worn camera. So at this point, I don't think there's any question about who the defendants were and the fact that they've been ID'd. We've also had several witnesses talk about the fact that this occurred in the state of Colorado and the County of Adams, and that was Debbie Furler, Ron Ryan, and Alicia Ward. We then go on to the dates of August 24th, 2019 through August 27th, 2019. And we also have evidence from Debbie Furler, who talked about the date on which the dispatch was made. We also have the exhibits of the body worn camera. And we also have, of course, Dr. Moss, who talked about the brain death on August 27th, 2019. So as a sort of high-level view of those three elements, for all the counts, the people believe that we have shown enough evidence in the light most favorable to the people that that should go forward to the jury, and we have met the Bennett standard. And going to the reckless manslaughter counts, which is for Mr. Cooper, count 11, and for Mr. Cichuniec, which is count 22, the reckless standard, which is when he consciously disregards a substantial and unjustified risk that a result will occur or that circumstances exist. The court can look at the defendant's own statements, which were that Mr. Cooper said that he knew ketamine had a risk of respiratory depression, and Mr. Cichuniec also issued a statement in his interview that he knew that ketamine had a risk of respiratory depression. We then had a series of witnesses, Sergeant Leonard, Mr. DeJesus, Mr. Bradley, Dr. Hill, Alicia Ward, Ms. Gonzalez, and even Mr. Travis Chambers, who talked about the fact that the significance of assessment and monitoring, and several witnesses said that there were no assessment and there was no monitoring. Dr. Hill talked about the protocols and the importance of assessment and monitoring. Mr. Chambers talked about the defendant's trainings, and that would be exhibits 230, 233, 235, 231, and the ketamine training 250, which all talked about the type of drug that ketamine was and the fact that they were trained that respiratory depression was a risk and that respiratory drive should be maintained with appropriate dosing, and appropriate was in all caps. We also have the fact that in this case, there's a significant evidence about how much was given to Mr. McClain and how much should have been given to him based on his weight. If the court will remember, they were trained not to give as a catch-all 500 milligrams of ketamine, that it was a weight dose dependent type of drug, and that they should have given him an amount that was consistent with his weight of 143. Instead, the defendants gave him the amount of ketamine that was even over the weight that they thought he would be. Instead of giving him the weight of 425, the amount of ketamine of 425 milligrams by kilograms, they gave him the catch-all of 500. This would align with a 220-pound individual. Of course, Mr. McClain was only 143, but even if you take what they did give him, or what they thought his weight was, he should have only gotten 425, and instead he got 500. This clearly was a choice that they made, and it was a deliberate choice they made when they knew the risk based on their training, the protocols. So they had an awareness of what the risks were and the fact that this amount of high doses should not be given carte blanche to every person. And then we have the element of cause of death of Mr. McClain. And the people would propose to the court that we had put on significant evidence on this case from Dr. Moss, Dr. Buther, Dr. Sina, and Dr. Mitchell. And of course, we have evidence from Ms. Freeman that Mr. McClain was in a healthy state prior to 2 weeks prior to the use of the ketamine. And we also have the shell videos that shows that Mr. McClain was a healthy individual, as also Officer Woodard's initial video that shows that Mr. McClain was a healthy individual as he walked down the street. So it is the people's position for counts 11 and count 22 that we have met the Bennett standard. Does the court have any question about those two counts?
I don't.
Going on, does the court want me to address the potential lesser included and the evidence therein?
I think the argument for reckless is sufficient.
Thank you. I now want to go to the 3 counts of second-degree assault. Second-degree assault count 13 for Mr. Cooper and count 24 for Mr. Cichuniec, which is what the defense is contending, is the elements are that it's a reckless cause serious bodily injury to another person by means of a deadly weapon. And the court, if the court goes to the people's motion, I think needs to consider the two-part test of what a deadly weapon is. First, the object must be used or intended to be used as a weapon. And I think that in this case, Judge, the facts are the object must be used. It's not a mental intent as far as the weapon. It's was it used in this case? And clearly there's significant evidence that the defendants knew that they were going to give ketamine to Mr. McClain. This is not the type of situation where it was a mistake to give the ketamine. It's not the kind of situation where they slipped and fell and then the syringe hit Mr. McClain. There is a direct action by Mr. Cooper after having the ketamine drawn up that he purposely leans down and uses the syringe to inject the ketamine into Mr. McClain's shoulder. So this is not a mistake. Unlike the Trent case where the car tried to veer off and not hit the car, and it was the people's opinion that they were not trying to hit the car. That was the evidence. But in this case, it's very clear that he meant to use the ketamine and inject it into Mr. McClain. There's no question about that. The question is whether or not the deadly weapon requires only that its actual or intended use, the object is capable of producing death or serious injury. I don't believe that that's really an issue in this case. I think there's been more than enough evidence to show that the ketamine itself is capable of producing death or serious bodily injury. It doesn't have to produce serious bodily injury. And in this case, we have shown that it did produce serious bodily injury and even death. So I think that the Trento case can be distinguished from the other case, which was when the man used his foot and hit the woman between her shoulder blades and kicked her down the stairs and she fell. This case is very similar to that case because the defendants started a series of events that went directly from the use of the ketamine to all the injuries that Mr. McClain suffered. It is like the foot in which foot is not normally a deadly weapon, but in the manner in which it was used, it propelled the victim down the stairs and results were a direct result of his using his foot. In this case, the defendant's use of ketamine is a direct result to all the injuries that occurred by Mr. McClain. And so he doesn't have the intent, doesn't have to be an assailant, but he has to direct his actions using the deadly weapon, which in this case is the ketamine, into the victim. This is not a mistake injection. He didn't mean it. He used direct action to put the ketamine by the use of the deadly weapon, the syringe and the ketamine together. And the natural result of that were all the cascading effects that Mr. McClain had as far as injury and then death. It is very different than the car case in which the victim was driving his car, trying to avoid the police and swerved to avoid the car, but then hit the victim's car. So it can be distinguished. In other words, Judge, they used the ketamine in a direct manner focused on Mr. McClain that was capable of causing death or serious bodily injury. Now, the defense would like to bring up the fact that there's a special relationship here and that you have to look at it as a medical provider. But I would urge the court that this is not the time to talk about affirmative defenses. That is a premature argument. We're here on the Bennett standard, and you have to look at it as, do we have enough evidence to get this in front of the jury? And then after that decision, you will have to decide, is the affirmative defense appropriate? But at this stage, you don't consider that. It is still a reasonable person who uses the ketamine in order to cause injury. And injury in this case is impairment. So it'd be as if a stranger came up to Mr. McClain and jabbed him in the shoulder with ketamine. That is where we are right now at this motion. We are not taking into consideration the affirmative defense. So in a very common sense type of argument, if anyone walked up to a person and jabbed them with ketamine, especially this amount of ketamine, and they had some training, which these individuals do, and they voided that training, and they gave an overdose of ketamine to the person, that would be a deadly weapon because they were purposeful in putting the ketamine in the victim's body. And they were purposeful in filling the syringe with a certain amount of ketamine. And they were purposeful in knowing, because of their training, that they should not use this amount of ketamine in this instance. So unlike other cases that the defense has cited, this is not a mistake. This is not an avoidance. This is direct action by these defendants towards Mr. McClain. The third thing I'd like to point out, Your Honor, is the evidence establishes that the defendants did not use this ketamine for a valid or lawful medical purpose. We have a lot of evidence from Dr. Buther, Dr. Robinson, Dr. Sina, perhaps not Dr. Sina, but Dr. Mitchell, that there was no reason to use a chemical restraint. This is not this type of situation. There was no medical purpose for the use of ketamine at the time that they administered it to Mr. McClain. And then once again, Judge, my last argument is, in the light most favorable to the people, there's sufficient evidence that ketamine was used in a manner capable of causing death or serious bodily injury. And of course, that comes from Dr. Mitchell, Dr. Buther, and even Dr. Robinson said it could cause serious bodily injury in a medical way, but we actually know it caused serious bodily injury by respiratory depression, then the ischemic brain injury. We know that from the aspiration in the lungs. So not only was it capable of causing serious bodily injury or death, but it actually did in this case. Even taking into consideration Mr. McClain's condition at the time, it caused further respiratory depression, spasm in the larynx, hypersalivation that all led to additional aspiration. And when you go back to the case in which the defendant kicked the woman in the shoulder blades and sent her down the stairs, I'm not sure how to say that name, Sally, 45 P. Second at 1276, it was a natural, continuing reaction and result of the initial purpose of why he put the foot in the middle of her back. It's a foreseeable result, Judge. You have to look at the degree of the injury inflicted. We have one moment, Your Honor.
You may.
And Your Honor, Magana at 2022 CO 25 is the current test of what a deadly weapon is. And the people believe that the argument I just made at the court is consistent with the holding in that case. And going to the second count of second-degree assault, which is the subsection of 1E for Mr. Cooper, that is count 16. For Mr. Cichuniec is count 27. There's also 2 counts of crime of violence. Count 17 is serious bodily injury. Count 18 is deadly weapon. For Mr. Cichuniec, count 29 is the COV SBI, and count 28 is the COV deadly weapon. And in this case, Your Honor, there's different elements. There's an intentional element, and it's for purpose other than lawful medical or therapeutic treatment. And it knowingly caused stupor, unconsciousness, or other physical or mental impairment or injury to Mr. McClain. And by administering a drug, substance, or preparation capable of producing the intended harm without the person's consent. So it's, of course, a very different subsection of second-degree assault. The proof or evidence of intention, Judge, which is defined as when his conscious objective is to cause the specific result prescribed by the statute defining the offense. I think the court has to view the two exhibits of the defendant's interviews. For Mr. Cooper, that's Exhibit 152, and for Mr. Cichuniec, that's Exhibit 150. And of course, both defendants talk about that they asked for and gave ketamine for sedation. And of course, Mr. Cichuniec said he knew ketamine caused sedation and made the decision to give it. I'd also would include the same argument about the weight and their training. They made the decision to use a certain amount of weight calculation for Mr. McClain. And even given their own weight calculation, they administered way too much ketamine, even according to their own weight. He should have been administered by their own weight as 425 kilograms, and instead they chose to give the entire vial, which is 500. That was an intentional choice on their part to give the entire vial when they have been told and trained that using the entire vial is not an appropriate decision, that you have to make it a weight-based dose because of the risk associated, the respiratory depression risk associated with high dosage of ketamine. When the court looks at the element of for the purpose other than therapeutic medical or therapeutic treatment, I think the court can reflect on Dr. Buther, Dr. Sina, Dr. Robinson, all talk about the fact that it was not given for a medical purpose. And even Mr. Cooper says in his interview, he acknowledges that he asked for the 500 milligrams of ketamine and he actually gave it. But the doctors all express that there was no reason to give the ketamine. This was a chemical restraint, and there was no medical purpose or therapeutic purpose to give it at this period in time. For Mr. Cichuniec, I would adopt the same arguments and facts for the fact that there was no medical purpose to give it at this time. And of course, in Mr. Cichuniec's interview, Exhibit 150, he says, I went up to the 500 because of his agitated state and his sign and symptoms of excited delirium. We know these protocols. We have to know them. It's a weight-based drug. So clearly, Mr. Cichuniec knew how he was supposed to use the drug of ketamine. And it is the people's position that the evidence goes against his belief that there was excited delirium. And in the light most favorable to the people, the court can accept the people's position. The next element is to cause stupor, unconsciousness, and other physical or mental impairment or injury to Mr. McClain. I think that the court can certainly take account of the body-worn camera. We also have evidence from Dr. Buther and Dr. Robinson that ketamine is designed to cause deep sedation, and that it did actually cause deep sedation and unconsciousness in Mr. McClain. Certainly in Sergeant News's body-worn camera, Exhibit 116, we see that Mr. McClain, the way that he's acting certainly implies or shows stupor, even though that's not legally defined. And someone is slapping him, and Mr. Cooper acknowledging that it had kicked in. And then the last thing, we have to show also that by administering a drug, substance, or preparation capable of producing the intended harm, we of course have the doctors, Dr. Buther, Dr. Lamb, Dr. Robinson, all saying what the harm was done towards Mr. McClain because of the administration of ketamine. And that would go certainly in both the Mr. Cooper and Mr. Cichuniec's interviews. They admit that they knew it was a drug. They knew that based on their training, that respiratory depression could occur. And then the last element is without the person's consent. And of course, consent can be viewed as cooperation in act or attitude pursuant to an exercise of free will and with knowledge of the nature of the act. And in this case, Judge, we have several witnesses who have said they never saw Mr. Cooper or Mr. Cichuniec ask for consent or engage in a conversation about consent. And we have this information from Mr. Jesus, Mr. Bradley, Officer Ward, Ms. Gonzalez, and Mr. Walker. We also have it from Dr. Buther and Dr. Robinson, who never saw any evidence on the body-worn camera that either paramedic attempted to get consent or did get consent from Mr. McClain. The people's argument on deadly weapon would be the same in these counts, and also for serious bodily injury would be the same. We have one moment, Your Honor.
You may.
I would also add, Your Honor, that in the theory of complicity, the people would like the court to consider that they are complicitors of each other. And so the actions of one apply to both. And certainly, that's all, leave it at that. Does the court have any questions about that charge?
I don't.
And going to the last count of second-degree assault, which is subsection 1G, this is Cooper, count 19, and Mr. Cichuniec, count 30. The element is with intent. So once again, when his conscious objective is to cause the specific result prescribed by the statute defining the offense. I think once again, Your Honor, we go towards the defendant's statements, their knowledge of ketamine, their knowledge of their training, their knowledge that they knew that the risk could be high, that they knew it was a sedative, they were aware that it could cause respiratory depression. And certainly Mr. Cichuniec knew that the dose was too high. Once again, going to the element of to cause bodily injury to Mr. McClain, bodily injury is defined as physical pain, illness, or any impairment of physical or mental condition. And people would submit to the court that in this case, bodily injury is really the impairment of physical or mental condition. So once again, in order to prove those elements, I would direct the court to remember Mr. Lamb's testimony, Dr. Buther's testimony, even Mr. Chambers' testimony, when it talked about that ketamine was a dissociative anesthetic, which in the people's position meets the definition of causing the impairment of mental or physical or mental condition. And certainly under Dr. Robinson's testimony, ketamine causes impairment and disassociation. We would also look at their training, of course, which is Exhibit 25. And then lastly, causes serious bodily injury to Elijah McClain. I believe I've already laid that element out in other charges. But of course, Dr. Buther, Dr. Robinson, either Dr. Sina talked about it caused the death and also had a high risk of serious bodily injury. And of course, serious bodily injury includes death. Or have any questions?
Not at this point. Thank you.
Thank you, Your Honor.
Any rebuttal based upon counsel for the defendant's review of the brief that you hadn't seen a little earlier, I guess?
Brief. I think I was clear the first time, but just to be clear, I think what is being missed is a very critical and important nuance. The question is not whether or not there was intentional action. The question is whether or not the ketamine was intended to be used as a weapon. And the people's argument and brief are glossing over this entire nuance of what constitutes a weapon. And that is this litany of cases that I cited to you, and that is what the Supreme Court has struggled with. And in looking at Mangana, Judge, they did not abrogate that at all. They did not overrule the prior litany of cases. It was still the intended, that was an arson situation, and they were basically saying you can't convert all arsons to per se crimes of violence just by charging them that way, but they go back and they still delineate the two-part test. And it's the intent to use the inanimate object, or the ketamine in this case, as a weapon, not whether or not it causes serious bodily injury or death. So kind of the converse of the double knife case, where the argument was that it couldn't cause it. What the court said is that that's not what we're talking about. The question is whether or not you intended. You may have missed, you may not be able to cause it, but when you use the weapon, are you intending to use it as a weapon? And in this case, there's been absolutely no evidence that the conduct of the administration of ketamine was that the ketamine was intending to be used as a weapon. So to look at the definition of weapon, to look at the series of cases that require that component is what I think the people are missing. They have to be able to establish that Mr. Cooper and Lieutenant Cichuniec intended to use the ketamine as a weapon. And I think when you look at the definition of weapon, it is very clear that there's been no proof of that at all in this case. And Judge, as to all the other counts, we stand on the record. We understand the burden of proof at this stage of the game. We stand on the record.
Yes. Thank you. Your Honor, in response to opposing counsel's question regarding the remaining counts, we would also stand on the record and state directly that with respect to defendant Cichuniec, the prosecution has not proven all of the elements of the remaining charges against him. But I want to focus my rebuttal specifically to the case Esparza-Tretto, which I quoted to the court earlier. The factual background of that case, as the court is aware, involves the use of an automobile as a deadly weapon. And in that case, the court notes that the only evidence was that, in fact, the defendant was trying to avoid using the car as a deadly weapon. And I think that puts this case is much more comparable to that, rather than showing intent to use it as a deadly weapon. And that premise comes directly from the testimony of Dr. Robinson, who said, the whole premise, and this is a quote from his testimony, the whole premise of giving ketamine is for excited delirium, and the reason we're doing that is because there is likely metabolic acidosis. Certainly, during any form of exertion, you can have lactic acid buildup, and that's what we're trying to prevent with the administration of ketamine. That is what the evidence has shown, that Mr. Cooper and Mr. Cichuniec were trying to avoid the ultimate result that occurred in this case by employing ketamine. And that puts it more in the context of they were trying to avoid using it as a weapon. And in fact, were using it as in the manner that they had been trained and for the purpose that Dr. Robinson has articulated in the prosecution's case in chief. I would also point out that opposing counsel made two statements that were directly contrary to the law. One is, all they have to do is use the ketamine. That is simply contrary to the edict of Esparza-Tretto. And also that the level of injury that resulted is a factor in determining whether something is a deadly weapon. That is directly contrary to Buell 442 P3rd 961, which, and I quote at page 35, whether an object is a deadly weapon does not depend on the ultimate result of the object's use. Thank you, Your Honor. That's all I have, unless the court has any questions.
I don't.
Your Honor, I'd just like the court to consider that the fact that the test is the object must be used or intended to be used as a weapon. So when I said the weapon, they used ketamine as a weapon, it is not our belief intended to be used. It is our position that they used the weapon, the ketamine, as a weapon. They actually used it. Something is used as a weapon when the defendant is using the instrument to injure the victim. Bodily injury means physical pain, illness, or any impairment of physical or mental condition. So if I misstated, let me clarify the record. It is the people's position that the defendant used it as a weapon and they caused injury because injury is physical impairment or mental condition. And that is what the evidence is in this case. And just really quick, on Magna, a defendant need not intend to cause bodily injury. And there's a Shala case that just says injury. So I just want to clarify that.
All right, matter comes before the court on the respective motions for judgment of acquittal concerning the certain counts in the indictment. And there was, I suppose, a focus. As noted by the people of the court, finds that there's certainly sufficient identification that's been provided in this case. The dates of offense and dates of death have been established based upon the standards. But the court, at this point of the trial, must give the prosecution the benefit of every reasonable inference which might be fairly drawn from the evidence, including circumstantial evidence. Second, the determination of credibility of witnesses is within the sole province of the jury and not the court. Third, the court may not determine the weight to be accorded to various pieces of evidence by resolving conflicts in the evidence. And there have been some conflicts. The one that was perhaps interesting to the court, maybe not the jury so much, was the, I suppose, the therapeutic amount of ketamine that was, it was described a little differently by Dr. Robinson than by Dr. Sina and Dr. Mitchell, but in any event, they're going to have to figure that out. Fourth, modicum of relevant evidence will not rationally support a conviction beyond a reasonable doubt, and verdicts in criminal cases should not and may not be based on guessing, speculation, or conjecture. In general, a court should not grant a motion for judgment of acquittal unless the relevant evidence, including the direct and circumstantial evidence viewed as a whole in the light most favorable to the people, is not substantial and sufficient to support a conclusion by a reasonable mind that the defendant is guilty of the charge beyond a reasonable doubt. The focus of the defense argument, and I pointed out the questions that I had yesterday based upon the case law that's, I suppose, developed over the last dozen or so years. And it started, I think, really with the Stewart case in 2002, but then took a bit of a jump in 2011 or so. The Magana case is, the court reads that in general with respect to the analysis of deadly weapon, and is the as far as the Trado case points out, there's no, at least until I suppose Stewart to a certain degree, there is no statutory definition of weapon, and it's kind of developed from there. And the Esparza Trado case, and that case was later cited really, or the standard as set forth was discussed in the Buell and the Lee cases, although again, in different contexts. The definition of a deadly weapon at the time of this offense anyway was a firearm, whether loaded or unloaded. That's generally what's referred to as a per se deadly weapon. And then, or knife, bludgeon, or any other weapon, device, instrument, material, or substance, whether animate or inanimate, and in the manner it is used or intended to be used is capable of producing death or serious bodily injury. As the Magana court pointed out, the analysis would be it is used or intended by the defendant to be used. And they break down, although there's a suggestion in Magana that that's intent means intent. It's a definition rather than an offense. So as the instruction committee has done, I suppose, in a non-statutory sense or non-criminal sense, they've interpreted intent as a desire or purpose. Here it would be used to use the ketamine as a weapon. Again, hearkening back to the as far as the Trado, which was denied and has been cited as authority by the Supreme Court subsequently. It's an instrument of offensive or defensive combat, something to fight with, used in destroying, defeating, or physically injuring an enemy based upon the dictionary definition. The court has had the opportunity and listened carefully to the evidence in this case and has had the opportunity to view the videos that have been shown and admitted in this particular case. The court would find, based upon that and based upon the standards as set forth in the Bennett case 514 Pacific 2nd 466 from 1973, Colorado Supreme Court, that with respect to whether or not the defendants Cooper and Cichuniec intended to use the ketamine as a weapon, which is the first step in the analysis of whether it's a deadly weapon, the evidence is not substantial and sufficient to support a conclusion by a reasonable mind beyond a reasonable doubt as to that element. So the court will grant the motion with respect to counts 13 and 24 in the respective counts the alleged deadly weapon as a sentence enhancer. That'll be the judgment of the court. We need to do our in-camera now.
Yes, and Your Honor, could I just ask clarification? Did the court also strike the sentence enhancer? I just didn't understand.
That's, yes, you said the respective sentence enhancers.
If you needed the number for Mr. Cooper, it was number 8.
There's actually more than that. I would need to go through all of them, I suppose.
The other ones were dismissed, so 14 and 15 have already been dismissed, so now dismissed would be 13, 14, 15, and 18. And what remains are 11, 12, 16, 17, and 19. I'm sorry, 20 and 21 were also dismissed.
Well, and the court does, I didn't specifically make the findings with respect to the other counts. So I'm going to go through those in just a moment. The court does find that with respect to the respective charges of reckless manslaughter and the lesser included of criminally negligent homicide, that the evidence is substantial and sufficient with respect to those counts. With respect to the counts pursuant to 18.3.2031E, the court would find that there is sufficient evidence for the jury to consider whether or not there is a well, there's a number of issues in that case, including lack of consent and for a purpose other than lawful medical or therapeutic treatment. Based upon the testimony, the evidence is that the officers, or I should say the firefighters, were trained that of really what the effects of ketamine are. That could certainly cause stupor or unconsciousness, and that was actually part of their purpose. Also, with respect to the counts pursuant to 18.3.2031G, the court does find that there's evidence that's substantial and sufficient that Mr. Cooper and Mr. Cichuniec, with the intent to cause bodily injury, which means any impairment of physical or mental condition, which again is part of the purpose of ketamine as trained, ended up causing serious bodily injury to Mr. McClain. And with respect to the, I think that's it. All right. Any clarification?
No clarification. That's just been asked that we can waive client's appearance for the injury. They can come back. I just want to
Whatever you want. We've got the jury room. It's got 12 seats, so we probably have enough.
Mr. Cooper's fine staying on.
All right. Why don't we take a couple of minutes and I'll have so I'll need to bring my laptop back into the jury room because I don't have one up here.
Sorry, Judge. Just to make the record super clear, defendants are not going to be released. We'll just wait on it.
Yeah, I was going to do that before we broke. Thank you, Mr. Slaughter. Mr. Cooper, Mr. Cichuniec, we're going to be discussing some issues in chambers that has to do with some of the issues in this case. You obviously have the right to be present during this discussion if you wish to do so. Mr. Cooper, do you wish to be present for this?
No, sir.
Are you thinking clearly?
Yes, sir.
Is anybody forcing you or putting pressure on you into making this decision?
No, sir.
Mr. Cichuniec, what's your desire? Okay, very well. All right, why don't we take a few minutes and we'll go back to the jury room. Please be seated. If I can have council approach. All right, the prosecution is rested. Does the defense wish to introduce any evidence or testimony?
Yes, Your Honor. On behalf of Mr. Cooper, we will call Dr. Kenan Hurd.
Up here to my right and around the glass panel, and I'll swear you in. You solemnly swear or affirm this testimony you're about to be You do. Thank you. If you please be seated, and I'll ask that you speak somewhat loudly or close to the microphone to ensure that all can hear you. Hello? That seems loud enough. If you could please tell us your first and last name and then spell your last name for my court reporter.
Okay, my name is Kenan Hurd, Kennon. Last name is Hurd, Heard.
All right, thank you. Your witness.
Thank you, Your Honor. Good morning, Dr. Hurd.
Morning.
Can I have you start by introducing yourself to the jury, if you would, and please tell us how you're currently employed.
Sure. My name is Kenan Hurd. I am a emergency medicine physician and a medical toxicologist. I work at the University of Colorado Hospital. I'm a full professor of emergency medicine and medical pharmacology and toxicology at the University of Colorado School of Medicine, where I teach medical students, resident doctors, and other providers about the treatment of emergency conditions, poisoning, and the use of medications.
Dr. Hurd, are you a licensed doctor in the state of Colorado?
I am.
How long have you been licensed in the state of Colorado?
Since 1996,
Are you board certified?
I am.
And in what areas are you board certified?
I'm board certified in both emergency medicine and medical toxicology.
You indicated that you currently are a professor at the University of Colorado School of Medicine. Is that right?
Yes.
How long have you been a professor there?
I think coming up on 10 years.
And who do you teach as a professor?
I teach in a medical school. I also, I teach medical students. I teach in the physician assistant program where we teach physician assistant students. I teach residents who are physicians who finished their medical school training but are still continuing their additional training in specialties such as emergency medicine, pediatrics, internal medicine, lots of other specialties.
Do you currently teach paramedics?
We have paramedics with us in the emergency department on occasion, but I don't directly have a role in teaching them.
Have you previously taught paramedics?
I did teach in the paramedic school in Colorado Springs probably 20 years ago.
Have you in the past been affiliated with the Rocky Mountain Poison and Drug Center?
Yes, I'm actually still affiliated with them as faculty, but from around 2003 to 2000, I think in 10, I ran the medical toxicology training program there, and I ran the toxicology service at Denver Health.
And are you referring to Denver Health Medical Center?
Yes.
In your association with Rocky Mountain Poison and Drug Center, what specifically were your job assignments?
Well, in running the training program, I was responsible for the training of physicians who wanted to go on and get board certification in medical toxicology, which is the evaluation and treatment of patients who are poisoned.
Can you briefly explain to the jury, Dr. Hurd, the difference between medical toxicology and forensic toxicology?
Sure. Well, essentially, medical toxicology is about treating patients with poisoning. Forensic toxicology is much more about determining if a medication or something was a cause of death. So we're more about taking care of living patients, where they're more about investigating people who have already died.
Besides being a professor, what else do you do with the University of Colorado Medical School currently?
Well, my main role there, as I mentioned, is teaching. I've been more active in research in the past. I'm not currently. I have a couple of smaller research projects going on at this time. And then I run at the hospital, I run the section of medical pharmacology and toxicology, where I supervise other medical toxicologists who, again, evaluate and treat patients with poisoning.
Do you also work as an emergency room physician?
Yes, I work in the emergency room. My primary job is in the emergency room at the University of Colorado Hospital.
And when is the last time you worked in the emergency room?
About 8 hours ago.
Your Honor, at this time, I'm going to move to qualify Dr. Hurd as an expert in toxicology and ask that he be allowed to express opinions in that area.
For dire or objection? You may.
Good morning, Dr. Hurd.
Morning.
I just wanted to follow up on that teaching that you did back, was it 20 years ago at the paramedic school in Colorado Springs?
Sometime around there, yeah.
Okay. What was your capacity there? Did you teach a whole course or did you give a lecture? What was it?
I was invited down to lecture to the paramedic students about, I believe it was primarily about treating poison patients.
Okay. So was it one lecture?
It was one, well, I did it a couple of years. I don't remember exactly how many. It was a couple of lectures in one afternoon.
And then in your current role, or actually throughout your career, you've never been a medical director for a first responder system, have you?
I don't have any training or role in emergency medical services other than 4 weeks of training as an emergency medicine resident.
All right. Well, that would have answered the rest of my questions. I appreciate that, Dr. Hurd. Thank you. There's no objection to the toxicology designation.
All right, any other objection? Didn't assume it would be okay. All right, the court will, based upon the record, allow the witness, Dr. Hurd, to testify and as to his opinions and explain to the jury topics relevant to toxicology.
Dr. Hurd, are you familiar with a drug called ketamine?
Yes.
Can you explain to the jury what ketamine is?
Ketamine is classified as a dissociative anesthetic. It's a relatively unique drug. It's kind of related to PCP. That may be another drug people are familiar with. It's used for pain medicine in low doses, and then it's also used to sedate patients. You can use it for patients who are undergoing operations. We use it fairly commonly in our emergency department. For example, if someone has a shoulder dislocation or maybe a fracture that needs to be realigned. We use it in children who need to have sutures that we can't get comfortable and have them hold still, so we can do a really good repair and get their skin closed.
And you indicated that you have been involved in research in the past. Does that include research into ketamine?
Yes. So I'd have to go back and look for sure. I was one of my learners we worked on a project where we looked at the use of ketamine. It was a while back, and I remember working with her on it. I don't remember whether I actually ended up being a named author on the paper or whether it was just something that I helped her with and was acknowledged, but not a named author.
Besides that, have you also reviewed literature, and do you stay current on literature involving lots of drugs, including ketamine?
Yes.
Is that basically a part of your job?
Yes.
Is ketamine an opioid?
No, ketamine is not an opioid. As I said, it's a dissociative anesthetic. It's a relatively really kind of a drug that's in a class on its own.
How does it differ from an opioid?
Opioids act in the brain by going through the blood and binding to an opioid receptor, which is just a part of the brain where the two connect. And then when it binds to that receptor in the parts of the brain that control things like pain and vomiting and sedation, it causes kind of all those symptoms. Whereas ketamine is a drug that binds to what's called the NMDA receptor, which is a different type of receptor. And when it goes, the part of the brain that it acts in is the part of the brain that sort of connects our thinking, aware part of the brain to the rest of our body. So when ketamine is present, especially in the doses that you'd use for sedation, the part of your brain that's awake and interacting with the world and responding to the world is sort of shut down, whereas the parts of the brain that sort of maintain the rest of your bodily functions like breathing, heart rate, blood pressure, those parts continue to work. So you sort of separate if you will, the top half of the brain from the bottom half.
As a toxicologist, do you specifically deal with and treat patients who have been poisoned?
Yes.
Is that a fairly frequent thing that you do?
Yes.
In the emergency room, do you ever have to evaluate and treat patients with severe agitation?
Yes.
How often would you say that occurs?
Probably close to once a shift.
I'm sorry?
Probably close to once every shift.
Okay.
Certainly several times a week.
Are you familiar with other sedatives such as, I think it's the generic name, you tell me, Versed?
Versed actually the trade name, but midazolam is the generic name.
And are you familiar with that substance?
Yes.
How does ketamine differ from another sedative like Versed?
So we talked a little bit about morphine and how it works. Midazolam is a benzodiazepine. It'd be similar to like diazepam or Valium, one people probably know well. These medications work at a particular receptor that's called the GABA receptor. And the GABA receptor essentially is responsible for slowing down nerve transmission in your brain. So people who receive midazolam, they become sleepy, slowly respond less. We can use it if they're having seizures where their brain control is sort of out of control to slow it down. Or someone it's also a medication we would use for someone with agitation to calm them down.
Okay. How does ketamine differ? You just described Versed. How does ketamine differ from that?
Well, again, midazolam, if you think of it, you become almost more sleepy. So you'll go through almost a gradual state where you'll go from being awake and alert to almost being more intoxicated, sleepy, slurred speech, slow to respond, all the way up to the point where you could potentially give someone enough to where they would have general anesthesia and they would not be, able to wake up at all. Whereas ketamine tends to be more of a drug that you would give, and early on you may see a little bit of sleepy, less responsiveness, but then you reach this point, a little bit of sleepiness that then progresses. But you don't, you tend to reach a point where once you reach what's called a dissociative state, it sort of becomes almost an all or nothing type of effect where once you're dissociated, you're not responding to anything, any external stimuli. You're sort of completely looking around, but you're not really asleep. Again, your breathing tends to be maintained, your blood pressure, your heart rate. So it's, if you looked at the patient, the way I've heard it described is someone who received a large dose of midazolam would look like they're sleeping, whereas someone who received a large dose of ketamine kind of looks more like the lights are on, but nobody's home, so to speak.
Okay. Does ketamine have a ceiling effect?
Yeah, so that's sort of one of the reasons that we tend to use ketamine is as you get to higher doses of a drug like midazolam, the effects tend to continue to get worse. As I mentioned, you will go through a stage of where you're a little intoxicated, maybe a little sleepy, up to the point where you're not responsive, and then ultimately potentially into a general anesthetic where you're completely unresponsive. Whereas ketamine, you'll give, and once you reach this sort of threshold dose, this dissociative dose, you tend to see sort of a leveling off of the effects. And giving more of the ketamine, you don't tend to get more. I mean, once you're dissociated, you're pretty much dissociated, and then you don't see more additive effects.
Have you yourself administered ketamine?
Yes.
Can you approximate how many times?
More than 100.
When's the last time you administered ketamine?
Today's Thursday, Tuesday.
2 days ago?
Yes.
Have you ever, in the approximately 100 times you've administered ketamine, had to intubate somebody, a patient?
So there are occasions where we will use ketamine with the intent to intubate a patient. So for example, if someone comes in and they're having severe asthma and they're not able to maintain breathing on their own, in that situation, we'll often use ketamine as a drug to put them to sleep, so then we can put in a breathing tube and take over their breathing for them to treat their asthma. So I've used it in that manner. When I've used it, for example, like I mentioned, we'll use it to fix a shoulder dislocation or to do a procedure on a child. In those situations, I've never had to intubate someone after we've used it.
How does ketamine compare to Versed as far as causing respiratory depression?
They're both relatively safe. However, when midazolam is used intravenously and given rapidly, it can cause respiratory depression.
What about
whereas ketamine is generally considered much less likely to cause respiratory depression. That's one of the reasons that we tend to use it. Is ideally it maintains, again, the idea that your top part of your brain that's awake and responding is not working, but the part of your brain that controls your breathing, your blood pressure, and your heart rate tends to be not less affected.
Is ketamine used in pre-hospital settings as well as in the hospital?
Yeah, it's because of this property of where you can have someone breathing, not fighting, sort of out of it, but maintain their breathing and blood pressure. There's been a lot of work using ketamine for pre-hospital transportation. The military uses it a lot. It's easy to administer, for example, to a soldier in a battlefield where you have a field medic that can give a dose of ketamine while they're arranging to transport the patient to a hospital. It's also been used in the early studies of this were actually done in Australia, where, as you know, in the outback, it's a long ways to get someone to a hospital. So you might have to give somebody a dose of ketamine so you can put them in a helicopter and they'll remain calm and easy to transport for the long flights to get them to where they need their medical care.
Have you previously testified as an expert witness in court, Dr. Hurd?
Yes.
You know how many times?
30 maybe.
Do you testify in both criminal cases and civil cases, or have you testified?
Yes.
Have you previously testified for the prosecution in criminal cases?
Yes, usually when I testify, it's usually for the prosecution. It's usually for an injury case where someone has been injured by another person and they ask us to come in and comment on the extent of the injuries.
And were you asked to review the case of Elijah McClain?
It was.
Can you tell us what items you reviewed in connection with your review of the Elijah McClain case?
If I can refer to my report, just so I don't get everything, but essentially it was,
Do you have that with you?
yes.
May he refresh his recollection by referring to his report, Your Honor?
Yes, the witness may refresh recollection by looking at the report, but should not testify from it.
All right. So if you would take a look at it, Dr. Hurd, I don't want you to read from it, okay? But if you could just take a look at it, and if that refreshes your recollection, let me know.
Okay. So in a nutshell, I reviewed autopsy, laboratory report, EMS reports, medical records. I think those are probably the main things.
Did you look at body cam footage as well?
I did.
Are you aware of the dosage of ketamine that was given to Mr. McClain?
Yes.
And are you aware of the blood concentration in Elijah McClain's body of ketamine at the hospital when he was transported there?
Yes.
I want to talk to you about the dosage that was given to Elijah McClain, okay?
Yes.
How much was that
500 milligrams.
per kilogram? Or I'm sorry, 500 milligrams total?
Yes.
Was that, to your understanding, more that should have been given?
Based on his body weight, that would be outside of the protocol for the Aurora paramedics.
And what about the actual concentration in his blood that was seen at the hospital? Are you familiar with that level?
Yes.
And what was that level?
Let me check. I believe it was 1.4. And I have to double check the units.
You need to refresh your recollection.
Yeah, if I can. 1.4 milligrams per liter.
What can you say about that amount of ketamine in Mr. McClain's blood?
So that amount of ketamine is within the range of what we would expect to see when ketamine is used therapeutically. It's a little bit towards the lower end, but it's in the range where if a dose were given with the intent to treat a patient with sedation for a procedure for an operation, this is within that's similar to what we'd see in that situation.
Okay. Are you familiar with the National Library of Medicine?
Yes.
What is that?
So the National Library of Medicine is something that's maintained by the U.S. government where they collect medical research studies. They also compile information. It's essentially a resource that really anyone, but primarily physicians, can use to gather information about medications, diseases, treatments.
And how does the dosage of ketamine Mr. McClain received compared to the range of doses recommended by the National Library of Medicine?
So in their specific review of ketamine, they report doses, the dosing range up to 13 milligrams per kilogram. So his dose was, I think, around between 7 and 8 milligrams per kilogram.
So lower than the range of doses recommended by the National Library of Medicine.
It was within the range. Again, the upper limit being 13, the upper number cited there.
In your practice, have you administered ketamine for agitated patients?
I have once or twice, yes.
Do you teach on the use of ketamine to your students, your medical students?
Yes, I have, for several years, I delivered a lecture to the medical students in their final year of medical school. And one of the things that we covered was medical emergencies. And one of the medical emergencies that we discussed was severe agitation. And in my discussion, teaching them about severe agitation, one of the medications that comes up is ketamine.
Okay. And what do you teach about the use of ketamine with an agitated patient?
Well, ketamine, again, because it is fairly easy to administer, can be given as an IM medication. It has a fairly rapid onset of action within a few minutes. And again, it's relatively less likely to cause respiratory depression compared to some of the other drugs. It's a very good choice for severe agitation. And in particular, what I tell our medical students is, while I'm fortunate enough to practice at a very large hospital with a large number of resources, I have a lot of help. It's not like it's, there's 20 or 30 people in the emergency department. So when I need help, I can get it. Many of the smaller hospitals that we have in Colorado will often be staffed by a doctor, a nurse, and maybe one other person. And in those situations, you can imagine that if you had a patient who was out of control, but had a medical emergency, that getting them rapidly sedated so that you could provide the emergency care that you need would require a drug that could work quickly. And ketamine is actually a very good choice in that situation when you don't have all the resources that you might have at a bigger hospital.
The amount of ketamine that was determined to be in Elijah McClain's blood at the hospital, is that a toxic amount?
No.
The amount of ketamine that was in Elijah McClain's blood at the hospital, is that a fatal amount?
It's much lower than the concentrations that have been reported in the vast majority of fatalities. Again, it's very difficult to say what a fatal concentration is because that's obviously not something we can study scientifically. What we end up with is reports of patients who presumably died from a ketamine poisoning, and then we have those blood concentrations, and it's lower than those. But I mean, there's not like a specific number that we can point at and say, oh, this is a, clearly this is a fatal concentration.
From the literature, the 1.4 milligrams per liter of blood, how does that compare to fatal doses seen in the literature?
As I recall, it's probably, I'd have to take a look specifically, but it seemed to have a vague remember around 7 to 8. So it's, or actually, I'd have to look to be sure. I don't remember the exact numbers of that off the top of my head.
At your report?
Yeah, I think it would have it in the report. I don't actually see the specific numbers. I'd have to go back to the original reference. I didn't actually put them in.
Okay. I believe you testified your words were much lower. Is that right?
As I recall, they were the concentrations of ketamine in blood of patients who were reported to have died from ketamine overdose was much higher than the range than the 1.4 that was recorded here.
How long does ketamine usually take to start showing a sedative effect on a patient?
It depends somewhat, well, it depends on how it's administered. When it's administered in a vein, obviously when you put the drug directly in the vein, drug goes straight from the blood vein into the brain, and it can happen, you can see effects within a few seconds. If it's given intramuscularly by a muscle injection, then it has to travel through the muscle into the blood and then into the brain, and that's a little bit slower process. So that usually will take a few minutes.
Do you know how many minutes? Are you able to put a number on that?
Somewhere in the 5 minutes, somewhere around that time, but it's going to vary from individual to individual.
And in your reviewing the medical records and the patient care records in this case, was it intravenously given or intramuscularly given?
It was given intramuscular.
So would you expect to see a slower onset, as you said, approximately 5 minutes in most patients?
Yeah, somewhere within, again, 3, 5, 7 minutes, somewhere in that time frame.
When you're in the emergency room, do you administer it intramuscularly or intravenously?
Generally, because we're dealing with patients where we're doing it for, again, a procedure, so it's an elective, or not quite elective, but it's not something that needs to be done this second. We're using it intravenous. There are certainly, when I trained in children where it's a lot more difficult to get an IV, I have used it intramuscular even for a bone reduction. Because again, it's just more difficult and more complicated to get an IV in a child. And because, at least at our children's hospital, they reported a fairly large experience with intramuscular and had very good outcomes. So we would use it intramuscular.
In the 100 or so times you've given ketamine, have you ever had observed adverse effects in the patient?
Yes.
And what kind of adverse effects have you observed?
Probably the most common adverse effect is when people wake up, they tend to be very disoriented and they can be very scared and frightened. Again, it's sort of you can imagine if your top part of your brain's been turned off and all of a sudden you wake up and you're very, confused. So that's probably one of the most common things. I've certainly seen people with vomiting, nausea. I've had 1 or 2 cases where the patient has had spasm of the vocal cords. So they wake up and they feel it's hard to breathe. And we've had to, it's usually pretty self-limited, but you can help the patient with take a bag and help them breathe a little bit. And that usually causes the vocal cords to relax and they do okay.
Is the use of ketamine contraindicated by vomiting?
By vomiting?
Yes.
Not specifically. Again, it would depend somewhat on the context. In that, if you were using it, I would probably not want to use it to sedate someone for an elective procedure. If they were vomiting, I wouldn't want to give them something that would make them feel worse. On the other hand, if I were using it for more of an emergency condition, and I needed to get someone rapidly sedated, then I would not consider vomiting a major contraindication.
Okay. And by contraindicated, what does that mean?
That you should reconsider whether this is the best medication to use.
Is it the use of ketamine contraindicated if somebody is suffering from acidosis?
Not specifically. Again, that's not always something. When you look at how ketamine has been used, the description of ketamine use in the pre-hospital setting for sedation, for rapid sedation of highly agitated patients, that's not specifically listed as a contraindication. And presumably, if you have a patient who is severely agitated, then they're going to have a high level of acid in their blood, or what we would call acidemia. So certainly, again, it's not something you can measure because when a patient's very agitated and out of control, you can't determine what their blood pH is. But there are, a very large experience with ketamine's use in the pre-hospital setting in patients who presumably had acidosis and the drug was used successfully.
The times that you've used yourself ketamine with agitated patients, were there adverse effects of its use?
Not to my recollection, no.
Did it basically do what you wanted it to do? It sedated the patient and allowed you to treat them medically?
Yes.
In the circumstances of Elijah McClain's case, did you form an opinion to a reasonable degree of medical certainty whether the administration of ketamine was reasonable?
Rephrase.
What's your opinion, doctor, on, given all of your review of what you reviewed in this case, what was your opinion on the administration of ketamine to Mr. McClain?
Which calls for increased exclusion. Also beyond the witness's expertise, even qualified purely as toxicology, not in pre-hospital care or standards. And so his opinion, ketamine in this situation is beyond his expertise.
Response.
Judge, I believe this is within his expertise. He is a toxicologist. He has testified on ketamine and the effects of ketamine. And I believe he's qualified to testify in the ketamine administration here.
All right, why don't I have counsel step up for a moment?
Dr. Hurd, you testified about potential adverse effects of ketamine. Is that right?
Yes.
How common are adverse effects with ketamine?
Well, to some extent, obviously, that depends on how you define an adverse effect or what you would consider an adverse effect.
Okay. What about problems with breathing?
I would say breathing problems are distinctly uncommon. That's one of the reasons that we select ketamine over another sedative, is it's less likely to affect the patient's respirations.
Are you familiar with a side effect over salivation.
Yes.
What is that?
Well, ketamine, one of the other effects of ketamine outside of the brain is it affects the salivary glands and essentially turns them on. So patients can start having a lot of drooling and salivation. And again, because their top part of their brain is turned off, they don't necessarily have the ability to swallow as well. And so you'll have a lot of pooling of saliva in the mouth.
How common is that as a side effect?
It's something we're aware of. I don't routinely see it when we use it for sedation in the emergency department.
What about vomiting? Is that a potential side effect of ketamine?
Yes.
How common is that as an occurrence?
Again, something that we're aware of, but not something that I would say we routinely see or routinely when medications frequently cause vomiting. For example, the general anesthetics, when someone's going to the operating room and they're going to receive a general anesthetic, they'll actually administer a medication specifically to prevent vomiting from those medications. Ketamine is not a medication where we routinely treat patients to prevent vomiting. So it occurs, but I would not say it's a common occurrence or something that we feel we need to preventatively try and treat.
If you do have oversalivation as an observed side effect of ketamine, how do you treat that?
Well, the first thing you would do would be suction the patient, essentially just take a suction device and clear their mouth. There are medications that you can use, which we sometimes use in the emergency department. I'm not sure that those medications would necessarily be available in a pre-hospital setting, though.
The use of suction, is that expected? Does that normally resolve an issue with oversalivation?
Yes.
Can you tell us, Dr. Hurd, you talked about the normal onset of sedation with ketamine. Can you tell us how long ketamine lasts in the system?
Generally, the doses of ketamine that we use last 15 to 20 minutes, somewhere in that range. Usually, if that's the reason that we like it, is it tends to go away fairly quickly.
Do you have an opinion to a reasonable degree of medical certainty whether Mr. McClain had a toxic ketamine concentration in his system?
I do.
And what's your opinion?
The concentration in his blood was not a toxic concentration.
Are you familiar with what's called the idiosyncratic reaction to medication?
Yes.
Has ketamine been observed? Do people have idiosyncratic reactions to ketamine?
People can have an idiosyncratic reaction really to any medication. So yes.
And what is an idiosyncratic reaction?
So it's basically a reaction that we don't know why it necessarily occurred, and we don't know how to predict that it will occur. For example, when I teach about medication reactions, there's what we call a dose response reaction, which would be if I give more of a drug that causes your blood pressure to go down, your blood pressure will continue to go down. And that's sort of a dose response effect. There are allergic type reactions. So if you're allergic to penicillin and I give you penicillin, you'll have a sort of typical allergic reaction, maybe a rash or vomiting or whatever that is. Idiosyncratic reactions are reactions that kind of occur out of the blue, and we don't necessarily have a clear, they can occur in different organ systems. For example, you can have idiosyncratic liver failure, or you can have an idiosyncratic seizure, or you can have an idiosyncratic effect in, on the bone marrow and low blood count. So they're drug reactions where we don't expect them and we don't necessarily understand why they occur.
Can you predict them?
By definition, you can't predict an idiosyncratic drug reaction.
Is an idiosyncratic reaction the same thing as an allergic reaction?
It is not.
What's the difference?
Well, an allergic reaction is when your immune system is sensitized to usually a protein or some other type of molecule, and your immune system detects that in your body and causes a again, stereotypical reaction, usually something like a rash or wheezing or vomiting. An idiosyncratic reaction, as I mentioned, can be lots of different things, but it's not sort of a typical, allergic picture.
Dr. Hurd, do you have an opinion, again, to a reasonable degree of medical certainty, whether the amount of ketamine given Mr. McClain could have been expected to cause life-threatening effects?
I do.
What's your opinion?
I would not expect life-threatening effects from this amount of ketamine.
Thank you, Doctor. I don't have further questions, Your Honor.
Questions from counsel for Mr. Cichuniec?
Thank you, Your Honor. Good morning, Doctor.
Morning.
So as I understand it, this ceiling effect that ketamine has, once you achieve the desired dissociative state, more ketamine makes that state last longer, not go deeper, right?
Generally, yeah. The idea is that once you have a certain amount of ketamine in the blood, you have this effect. The top part of the brain is shut down. If you give more of it, it will take a longer time for your body to clear it and get down below that threshold. So that's why more ketamine causes a longer effect.
And just to put it in terms that I can understand, that makes it dissimilar from opioids in terms of the more opioids you take, the greater the effect of the opioid.
That's correct.
Okay. So to put it in even more layman's terms, if I drink alcohol, I get to various points of intoxication, right?
Correct.
And I can literally drink alcohol until I pass out or even pass away, right?
Correct.
Whereas ketamine doesn't have that function.
Yes, that's correct. I suppose there is some effect where if we got to very high doses, so not necessarily, if you look at obviously you can't poison people. So you can't determine what a lethal dose of a drug is in a human experimentally. If you look at animal studies, you can do this in mice, and the dose of ketamine that causes a lethal effect in a mouse, I'd have to go back and look, but it's somewhere between 10 and 100 times the therapeutic dose that we would use if you were, when we do surgery on mice, if you were using it therapeutically in a mouse.
You said you'd have to go back and check. Is that information in your report?
No, this is just something that from prior work when I was doing research that we looked at.
So that's something that's in the literature.
Yes.
And I'm sorry, how many times over the therapeutic dose did you find lethality in mice?
I'd have to go back and look specifically, but I want to say it was between 10 and 100.
So 10 times the amount of a therapeutic dose to 100 times the amount of a therapeutic dose to cause death in mice.
In a mouse, yes.
And just as they are in human beings, ketamine doses are delivered by weight in mice, correct?
Yes.
You talked a little bit about respiratory depression. And respiratory depression is a potential side effect of ketamine, correct?
Yes.
Are there studies out there that show how often respiratory depression occurs in various administrations of ketamine?
Yes, I'm sure there are.
Have you reviewed any of those?
Not specifically.
And respiratory depression, can you explain for the jury what respiratory depression means as a term?
Sure. So respiratory depression is pretty much what it sounds like. Essentially, your breathing slows down and your breathing becomes less deep. So you're not moving as much air in and out of your lungs.
But respiratory depression doesn't necessarily mean you stop breathing.
That's an extreme form of respiratory depression.
Okay. So when you say that ketamine has a side effect of respiratory depression, you're not saying that it causes you to stop breathing.
Yeah, I'm not aware of any research that suggests that ketamine causes respiratory arrest. It generally, if it's, again, generally ketamine is considered to preserve respiratory function so that you maintain your respirations. There are reports of patients having slowed respirations or less respirations, but I'm not aware of cases where someone stopped breathing from ketamine.
Thank you, doctor. And in that, you said that sometimes ketamine can have a respiratory protective effect.
It's generally considered to be respiratory protective, that it maintains or perhaps even increases a little bit how much people are breathing.
And it's also a bronchodilator, right?
Yes.
And what does that mean? Can you explain that for the jury?
Sure. This is the reason that, as I mentioned earlier, we use ketamine often if someone has a severe asthma attack and we have to put them on a breathing machine, is that the small part of your airways have muscles in them that open and close. And that's what asthma is. If you have bad asthma, your small airways start to close off. And we'll give you medicine to try and open those up, because if we get those airways open, then we can move the oxygen all the way through your lungs. Ketamine has some tendency to sort of help those muscles open up.
Thank you, doctor. Is that one of the reasons that ketamine is considered to have a wide safety margin?
I don't think that specific characteristic would be one of the things that we would look at.
But you would agree with me that ketamine is considered in the medical community to have a wide safety margin.
Yes.
And can you explain for the jury why that is and what a wide safety margin means?
Sure. So a safety margin essentially means what's the difference between the amount of drug that we can give to cause the effect we want versus the amount of drug we have to give to cause a toxic effect. So the bigger the difference, the better, because then you can give a drug up, get the effect that you want, and know that you're not getting anywhere near the amount where we would expect to see toxic effects. So ketamine, again, is a drug because of this, as we've talked about, the ceiling effect, where once you get up to a certain amount, giving more of it doesn't tend to cause more of the same effect. So that's one of the reasons that ketamine is considered safe. It's one of the reasons, again, we use it a lot in pre-hospital medicine, because you don't have, you're not in an ICU, you can't monitor the patients as closely. So it's got a lot of characteristics that say, because of the safety of it, we can use it and not use it under quite as tight of circumstances as you need to use other drugs.
So you just mentioned that you can use the drugs in circumstances where monitoring would be difficult.
Correct.
And can you use it in circumstances where assessment of a patient would be difficult?
I'm not sure what you're asking.
So you said that you had situations where, well, maybe explain to the jury what you mean when you say in situations where things aren't quite as tight or monitoring would be difficult.
Okay. Well, I think, the best example would be, as I mentioned, in the battlefield. So when I'm working in the emergency department, fortunately, I have all the monitors, all the nursing staff, everything that I can watch, your breathing, your blood pressure, your temperature, your heart rate, all those things are immediately available in multiple settings. And they're easy to do because the patient's laying there and they're not moving and I can treat them. But if you're, for example, on a battlefield where somebody has had part of their arm or their leg blown off, and you're trying to get the patient evacuated out of a dangerous area, you're not going to be able to keep the patient still. You're not going to be able to put the patient on a heart monitor and a breathing monitor and all those other things. So ketamine has, because of the minimal effects on breathing and blood pressure and heart rate, ketamine's a wonderful choice for that, because I can give it, and then as soon as I can, get the patients on the monitoring that we need, but realize that as opposed to a drug like some of the opioids like morphine or the benzodiazepines like midazolam, I'm not likely to run into as many problems with breathing as I would with those drugs.
Thanks, doctor. Can I have a minute?
Yes.
Thank you, doctor. I don't have any further questions.
Cross-examination by the people.
Have you have any idea when you would like me to stop for a morning break or what you want me to do for timing?
Well, we got started around 10, so we can keep going for a little bit.
Good morning, Dr. Hurd.
Morning.
I'd like to start with that last thing that you just said there. That ketamine makes for a good battlefield medication because, and I wrote it down, that after you give it to them, quote, as soon as I can, get them on monitoring. Is that what you said a couple minutes ago?
Yes.
Can you tell me why that's so important to get somebody on monitoring, even in a battlefield setting, as soon as you can?
Well, I think because patients, especially in a pre-hospital setting, are inherently in a state of flux. We don't know whether they're going to get better. We don't know whether they're going to get worse. And the only way we can figure that out is by seeing, what their heart rate's doing, what their blood pressure's doing.
I want to break down a few of those things there. So first, finding out what their heart rate is doing. What sort of techniques can you use, even in a battlefield setting, in order to measure somebody's heart rate?
Well, as you pointed out, I'm not really a pre-hospital medicine person, so I'm probably not qualified to comment on that.
Sure. Through your general medical training, you know that you could measure heart rate by taking somebody's pulse.
Sure.
Or if you wanted to measure things related to their breathing, you could hook them up to a pulse ox machine.
Yes.
Or a capnography machine.
Yes.
Are those the kinds of monitoring that you're talking about that are so important to get in place as soon as you can get them on monitoring?
Well, again, I practice primarily in the hospital where I have all those things immediately available. So certainly in my practice, that's part of it. But I don't have any experience in disaster medicine, pre-hospital medicine, or war medicine. So I'm sure ideally that's what they would use, but I don't know the specifics around the time limits or what they would consider a reasonable amount of time.
Well, I want to talk a little bit more about that idea, Dr. Hurd, because you've mentioned a few times that ketamine is safe. And when you talk about that, you're talking about your personal experience, first of all, that you find it to be safe in the emergency room with all that monitoring equipment, right?
Correct.
And in the 100 times or so that you have personally used ketamine, would it be fair to say that you always do an assessment to make sure you are using it on the right patient?
Yes.
Would it be fair to say that you always make sure that you're giving them the right dose?
Yes.
Would it be fair to say that every time of those 100 you use ketamine, you always make sure that you've got the right monitoring equipment ready to use as soon as you can?
I have the standard monitoring equipment that's part of our sedation protocols, yes.
So would it be fair to say that you have the right monitoring equipment there to use as soon as you can?
Like I said, our use of the ketamine and really all the sedative drugs are pretty protocolized. When you say right, I think, if you could clarify, I think that for my department, for my setting, yes, I have the right medications and right monitoring and right people there.
Would you also say that in all those 100 times you use ketamine, you make sure that you've got the right interventions ready to happen in case there are side effects from using ketamine?
One of the benefits of being in the hospital is, yes, we have all those tools immediately available.
Sure. And in your report, you talk a lot about how you have these ideas of ketamine safety or the wide margin because of all these studies. And in those studies, everybody was supposed to be following protocols so that they would be using ketamine on the right patients, right?
I'm presuming that they're using them. Yeah, the pre-hospital studies, ketamine is usually administered as a part of a protocol that's developed by the individual systems.
Sure. And the studies you've examined were supposed to be using the right dose on that patient.
Yes.
And those studies you've examined were supposed to be using the right monitoring equipment after dosing the patient.
Yes.
And with the right interventions on hand in case something went wrong.
Yes.
So I think we all agree that ketamine, if you use it on the right patient, the right dose, with the right monitoring equipment and the right interventions ready, it generally is pretty safe, right?
Yes, and I think it's important again to stress that the dose is there's a very wide margin of safety on the dose. But I mean, as with any tool, a tool must be used properly in order to be used safely.
And if all those four things are true, from all the studies you've reviewed, the right patient, right dose, right monitoring, right intervention, you're actually not aware of a single person who's died because of ketamine.
No, I mean, it's always difficult the problem, especially in this setting, is that these are very complicated patients with a lot of medical conditions.
Doctor, I'm sorry. You were just telling me how you're not qualified to evaluate what happened in this case.
Judge, I'm going to object. He was answering the question, got cut off.
All right, you can ask a different question.
So my question is just whether you are aware of any patient dying from ketamine who was the appropriate patient, so the right patient, given the right dose, with the right monitoring equipment, and the right interventions ready. Are you aware of anybody dying under those circumstances?
From ketamine poisoning? Not from ketamine poisoning.
Now, despite that, though, ketamine does have some well-understood potential side effects, right?
Yes.
One of those side effects is hypersalivation.
Yes.
One of those side effects is respiratory depression.
Rarely.
It is a well-known and understood side effect.
Yes.
And one thing that can happen, particularly in pre-hospital settings, is a risk that a patient would need to be intubated, right?
Yes, patients are frequently, or at least in the initial studies, were intubated fairly frequently with ketamine administration.
So I want to get back to this frequent intubation that you just mentioned, but first I want to make sure that I'm understanding what intubation is correctly. So intubation, that's where you put some sort of physical device into the airway to keep it open. Is that right?
Yes, that's correct.
So it's done in cases where there may be an obstruction like aspiration in the airway?
That would be one situation, yes.
Okay. It can be done if there is respiratory depression and somebody needs to have more oxygen forced down into their lungs.
That's correct, yes.
Okay. And you mentioned that in pre-hospital settings, intubation happens frequently. I mean, the rates of intubation for pre-hospital ketamine, they're crazy high, aren't they?
It depends on what literature that you look at. The one study, again, that I mentioned earlier, that was one of the earlier studies looked at this, they actually, a majority, I'd have to go back and look at the exact numbers, but a not small number of those patients were actually transported and then intubated after they arrived at the hospital. They were not intubated by the paramedic teams. And I'm sorry, I don't recall off the top of my head what the proportions were.
Thankfully, I've got the numbers ready for you, doctor. So, for example, in the Olives study that you cited,
Yep.
63% of patients who got pre-hospital ketamine had to be intubated, right?
Again, a large number of those were intubated in the emergency department, not in the pre-hospital setting, but that number sounds correct.
Sure, whether they were intubated, in the ambulance or once they got to the emergency room, though, almost 2/3 of them had to be intubated.
Well, I think I have a little trouble with the term "had to be." The judgment of the physician who was developing an experience with ketamine and what patients who had been treated with pre-hospital ketamine would present with felt that they should be intubated. And then, as I mentioned, over time, as people became more familiar with that, the belief was that many of those patients probably did not actually need to be intubated.
Okay, so the number might be less than 60%. It might be like 30%. I mean, we're still talking about a very high percentage of patients requiring intubation, right?
I don't think we have that number, a clear estimate of that number at this point.
Okay. So if you had a group of, say, 12 people, 8 of them could potentially receive intubation if they got pre-hospital ketamine.
I mean, if you're just going off the math, then that sounds correct. But again, I don't know that is necessarily the right number.
Well, it's the number that actually were intubated in the Olives study, right?
Correct.
So you talked a little bit about the ceiling for the dissociative effect of ketamine, and that's pretty well documented in the literature, right?
Yes.
Essentially, you start giving somebody ketamine, and at a pretty low dose, like 2, 3, 4 milligrams intramuscular, they reach this dissociative state where they don't really know what's going on around them, but then they just don't get more dissociated. Am I understanding that correctly?
Right. Dissociation is either there or it's not.
Yeah, so sometimes the studies will describe it in that binary on or off kind of way, which is different than a lot of other kinds of sedation, right?
Correct.
Now, there are some indications in the studies, though, that ceiling effect for disassociation is not necessarily present for side effects. Is that right, doctor?
Yeah, I mean, side effects can essentially happen pretty much throughout the spectrum of dosing. It can happen at low doses, high doses, but yes.
And I want to break down those two things. So first, side effects like hypersalivation or respiratory depression can happen at low or high doses, correct?
Yes.
But I'm specifically referring to the ceiling effect. And you're aware that there's studies out there indicating that there isn't really a ceiling effect when it comes to the side effects from ketamine, and that more dosing can increase the risk of some of those side effects.
Some of the side effects, yes.
Okay. For example, in the National Library of Medicine article that you cite, they indicate that there may be respiratory depression if the medication is administered at too high of a dose, correct?
It is certainly is likely dose related.
Yeah. So when we say that the risk of respiratory depression is dose related, what we're saying is that there's not a ceiling effect with the risk of that, right? The more dose will lead to more risk.
I mean, yes, there is a small risk, and that risk does go up with higher doses.
And that's why that same National Library of Medicine article that you cited, right after talking about that risk, says that the physician has to be ready to perform emergency intubation because of that risk, right?
I don't recall that specific quotation from it, but certainly we are prepared to manage the airway when we use ketamine.
Yeah, you'd agree with the idea that because of the risk of respiratory depression, somebody needs to be ready to provide emergency intubation if it's necessary.
Yes.
You also cite in your paper to a study done by Fernandez, the big meta-analysis of like 11,000 ketamine recipients. You remember that?
Is that the one that's the meta-analysis, or is that the one that's the analysis of the national data set for EMS? I think the meta-analysis is smaller than that. I think the meta-analysis is a study of 600 patients or something like that.
You're right. It's the national study of all the different patients in the EMS. That was my misuse of the word meta-analysis. Thank you, doctor. And would it be fair to say that of all the different studies that you referred to in your report, the Fernandez study is the most recent since it was from 2021?
Sure, yeah.
And by far looked at the largest number of patients with 11,000, right?
Yes.
Most of the other studies that we're talking about are a few dozen people, maybe 150 or so.
Yes.
And Fernandez concludes the same thing, right? That there's a risk of respiratory depression, particularly if the medication is administered too quickly and at high doses. So Fernandez agrees with the National Library of Medicine, right?
That's true. There is a risk that is small, but there is a risk.
And that risk increases with higher doses.
The risk remains small, but does increase.
Now, Dr. Hurd, I'm not a doctor, but I do pay really close attention to words as a lawyer. In your report, you wrote, there is a ceiling effect where larger doses do not produce more severe effects. In your report, you wrote, once a threshold dose is administered, the expected effects remain similar but prolonged when higher doses are given. Am I reading that correctly, that the word expected effects there was a deliberate choice by you?
Try to use the right words, yes.
Because the expected effects like disassociation or absence of pain, those do remain similar but prolonged once the dose increases.
Yes.
But the side effects, risks like respiratory depression, as you just confirmed, go up when dose goes up.
Yes.
You did not mention that fact anywhere in your report, did you, Dr. Hurd?
I'd have to go back through the report specifically, but I don't, if you say so, I'll agree.
Well, if you were trying to make the point in your report that higher doses have higher rates of respiratory depression, you'd remember trying to make that point, wouldn't you?
Yes.
Now, you mentioned on direct some discussion of dosing. And I wanted to talk a little bit about that because you said that the dose from the National Library of Medicine that's recommended for intramuscular is 6.5 to 13 milligrams per kilogram. Is that right?
I think I have 3 to 13, but somewhere in, 6.5.
Well, the 6.5 to 13 dose, that, as you testified on direct, is what's recommended for surgical intervention in a hospital, right?
That certainly is within the range that they would use for surgical intervention, yeah.
We'll talk a little bit more about those distinctions in a minute, but I forgot to ask you earlier just a little bit about your arrangement with the defense attorneys here. How are you being compensated?
I'm paid an hourly fee.
What's your hourly fee?
The medical school has said it, or my department has said it, I think it's $400 an hour.
Okay. Do you know about how many hours you've worked for the defense on this case?
I'd have to guess, 20, maybe 30.
Okay. And you haven't sent any invoices to the defense for them to share with us, have you?
I've sent one invoice to the defense.
Do you know about how much you've billed total in these cases?
How much I bill total in this case? So far, I think maybe $3,000, something like that.
Didn't you just say that your rate's $400 an hour and that you'd worked 20 to 40 hours?
Yeah, I haven't billed all of my hours yet.
Okay. So you don't know what your total expenses are yet. Do you have an estimate of what they will be?
I guess that it's probably going to be 20 hours. I don't remember where we started off, where we left off.
Now, you also discussed with the defense attorneys idiosyncratic reactions. Those usually occur or are most well known to occur in drugs that are new or they're not well understood.
Well, yeah, if you have a drug that is new and hasn't been studied and you see a reaction that you haven't seen before, it's idiosyncratic. And then if you collect information on it over time, it becomes more clear and then it's no longer categorized that way. So logically, yeah.
Yeah, exactly. When something is not well studied, reactions might be categorized as idiosyncratic until they're understood.
Yes.
Now, ketamine's been in the use since the 70s, right?
Yes.
About 50 years?
Yes.
Now, the Fernandez study, 11,000 patients that we talked about earlier who got ketamine, in that 11,000 patient sample, you're not aware of a single fatal idiosyncratic reaction to ketamine in that study, are you?
I'm not. I would say that study wasn't really designed to detect those. That was a registry study looking at paramedic data. So it's not the kind of study that would really be a good study to detect that.
Yeah. And to be clear, although you're acknowledging idiosyncratic reactions exist, you're not saying Elijah McClain had an idiosyncratic reaction.
No.
Now, I meant to grab my chart thing here. So we grab that. I wanted to talk a little bit about the dosing issue that you mentioned on direct examination there. So the first thing you talked about was how the amount of ketamine in Elijah McClain's blood at the hospital was 1.4, was it milligrams per liter?
Yes, I believe so.
And you mentioned that that's considered the therapeutic range. That's according to the Basalt textbook on toxicology, right?
So the Basalt textbook is basically a book that compiles medical literature and puts it in there, and that's, you know, they gather it from other primary research or sources. So they'd look at research articles in other places. I think I also looked at some other primary research articles, probably the ones that were cited in there, and looked at them. But that's where it comes from.
Yeah, and the way that Basalt explains it is that therapeutic range is for use of ketamine in surgery. Is that right?
It would be what you'd expect when you're trying to get someone sedated. I think the majority of those studies were in patients who were getting it for surgery. Some of them were what we would call early phase studies, where you're trying to just describe the concentration of the drug, and that may be something that you do in volunteers.
Okay. So that therapeutic range, we're talking about a surgically anesthetic dose. Is that fair?
We're talking about a dose that in those studies was used for surgery that is also similar to what is used for rapid sedation of agitated patients. I mean, we're talking, a dose is a number. You can use doses for different things and in different conditions. And in some conditions, the same dose is used. So the dose for this is relatively the same as the dose that's used for surgery.
I want to talk a little bit about dosing with you in a second, but right now I'm just talking about the therapeutic range of the blood concentration. That number that you're drawing on from Basalt and the underlying studies is talking only about the therapeutic range for surgical anesthesia. It is not talking about the therapeutic range for pre-hospital sedation, correct?
So I guess the problem is I just don't think about it that way. I think about a dose as a number of milligrams or milligrams per kilogram, and then that dose is going to produce an expected blood concentration. So if I give the same dose for two conditions, I would expect the same concentration of drug in the blood. So, I mean, those particular studies, we're looking at a dose. The condition that the dose was given for was surgery. But
the salt therapeutic range that we're talking about of 1.4 milligrams per liter, that's not talking about dosing. That's talking about blood concentration, right?
sure,
So that's the amount that's in somebody's system after they get whatever dose it was that they got before.
right.
And Basalt says that that is within the range of therapeutic blood concentrations they would expect for surgical anesthesia.
For the dose given for surgical anesthesia.
Now, that level that Mr. McClain had, when that blood was drawn at, what was it, like 39 minutes after the hour, was 30 or 40 minutes after he was given ketamine, right?
I thought it was, if I can check my report, but I think I thought I want to say it's 20 some odd minutes. Yeah, the peak let's see, 2300, 2339, so 39 minutes.
Yeah. And the ketamine was administered at, well, depending on who you listen to, 00 or 01 after the hour.
Yeah.
So we're talking about 38 or 39 minutes after administration.
Yes.
And the peak administration, you testified on direct, is about 20 minutes after IM administration. Is that right?
Yes.
So is it fair to say that although we can't predict the number, Mr. McClain definitely would have had a higher blood concentration before he got to hospital than when the blood was drawn?
Yeah. I mean, it's always difficult to say, but probably I would say more likely than not.
Now, the testimony you gave on direct was that although the dose that Mr. McClain received was in excess of his protocol, but you've been saying that it's a therapeutic dose. Is that correct?
I I mean, it's in excess of the recommended dose per the protocol. So it's, I mean, it's by definition an overdose.
And in your report, you discuss how that although it is an overdose, you think that is within the range of doses recommended by the National Library of Medicine. Is that right?
Yeah, I mean, I think as with anything, an overdose, there's degrees of overdose, and this is an overdose, but this is not a huge overdose. This is not an overdose in the range where we would expect to see severe effects.
And by expect to see severe effects, you're referring to ketamine toxicity or poisoning. Is that right?
Yes.
Because I want to distinguish between this idea. Ketamine toxicity and poisoning, that only happens at really extreme levels of ketamine. Is that fair?
Yes.
And that's where the level of ketamine is just so high that the ketamine, straight out, nothing else, just kills them.
Correct.
But people can die after getting ketamine from the predictable side effects of ketamine if they're not treated and they don't get the right interventions, right?
Yes.
So when you say that this isn't an overdose that you would expect to kill him, you're just saying you don't expect it to outright cause a poisoning. Fair?
That's fair.
Okay. But as we've discussed, the dosage does matter, and more dosage is more risk of respiratory depression, right?
As I said, there is a small risk of respiratory depression, and if you give more, that small risk increases. Relative to other drugs, less, but yes.
So I want to break down a little bit about this dosing then. Now, you mentioned in your report that although the dose was outside of the protocol, you stated it was within 5% of the dose allowed by the protocol in cases when a second administration is recommended. Is that right?
Yes.
So I want to understand what that means. So let's sort of start with our baseline of Mr. McClain here. He weighed 143 pounds, right?
That was his weight, recorded weight in the ICU.
Okay, so I'm going to write in the bottom left, EM 143 pounds. Now, the appropriate dose under the protocol for somebody of his weight would have been 325 milligrams. Is that right?
That sounds right.
So I'm going to draw a little bar up and put 325 mg. Now, in your report, when you were talking about the dose he got being within 5% of the dose allowed by the protocol in cases where a second administration is done, you meant that the first administration would have been somebody who got the max dose of 500 milligrams, right?
So that would be the dose of 5 milligrams per kilogram at his body weight. So not necessarily 500. I'd have to go back and do the math. But so I believe it was if we did the 325, and then you gave a second dose of 2.5, that would get you to around 500.
So, and you go ahead and take a look at your report if this refreshes your recollection. But there you're talking about the maximum dose allowed under the protocol under all circumstances, right?
Yes.
So the maximum first dose under the protocol for somebody is 500 milligrams, right?
Yes.
And that's for somebody who's at least 220 pounds.
I mean, that would be the weight-based dose, but yes.
Yeah, 100 kilograms, 220 pounds.
Yeah.
All right, so I'm going to write 220 pounds and draw a line up to 500 milligrams. now we say 220 pounds or 100 kilograms there, but that's also the maximum dose for like a 300-pound dude who's built like a defensive tackle, right? Like 500 is just the max for a first dose.
Yes.
Okay. Now, under the protocol, as you were outlining in your report here, if somebody gets this maximum dose and they're still out of control, they can call back to the base to get a second dose, right?
Yes.
And that's half the dose of the maximum dose. So 250 more?
For a 220-pound person, sure.
Yeah. So that's 750 total.
Yeah.
So I'm going to write call ER and then 750. So if you have somebody who's 100 kilograms, got the max dose, still out of control, they call the ER, they give him the next max dose, that person would have received 7.5 milligrams per kilogram, right?
Correct.
So I'll write 7.5 milligrams per kilogram. Now, Dr. Hurd, the dosage by weight that Mr. McClain got on his very first dose is higher than that, isn't it?
It was 7.7 milligrams per kilogram. So that, yes.
So I'm going to put a dot up there with EM and say 7.7. And that's, as you said in your report, a little bit less than 5% more than the max dose under the protocol for somebody who got a max dose, was still out of control. They called the doctor gave them permission to give another max dose, and then they got 750. It's a little bit more than 5% over that.
Yeah.
That's all I have for you, doctor. Thanks.
I'm considering taking a brief recess, maybe a 10-minute, just to allow folks to stretch and maybe get a water or something. So we're going to take a quick break, folks. Don't form or express any opinions or discuss the case. Do no independent research. Hopefully, my staff can just take you back into the jury room so you can take care of whatever you need to, and we'll have you back in about 10 minutes. All right, the jurors have stepped out. Let's have everybody back.
I do have a couple more questions for you, Dr. Hurd. You were asked about high doses of ketamine being administered and studies observing that. Do you recall that?
Yes.
And you testified about a 10 to 100 times the therapeutic level. Do you recall that?
I think was that when we were talking about the animal studies? Is that what you're asking about?
A study that had adverse side effects, and you testified about, you believe the dosages were 10 to 100 times the therapeutic amount.
Response?
I believe he testified to this during cross-examination, Your Honor.
He did during direct examination, not cross-examination. He was asked about the study, though.
Right. Okay.
I believe that he testified to that during my cross-examination.
All right. Well, cross or direct, so I'll allow you to go into it.
All right. Do you recall that, whatever table it came from, do you recall that line of questioning, Dr. Hurd?
I do, but I believe that was in regards to animal studies, studies in mice.
Okay. The studies that you have reviewed regarding intubation, did those involve IV or intramuscular administration of ketamine?
I'm not clear which studies that you're asking about.
Dr. Hurd, are there studies in which, are some of the studies referenced by you involve pediatrics?
Response?
Judge, I believe one of the studies he referenced did involve pediatrics. I don't know if he specifically used the term pediatrics.
Well, if the question was not in the context of pediatrics, the court would find it's beyond the scope.
Okay. Does IV administration versus intramuscular administration make a difference in side effects?
Should also be in the scope. Ask about difference between that.
He was asked about side effects of high doses, Your Honor.
Yeah, so I think that that question is within the scope of that cross-examination to at least clarify.
So I'm not aware of any specific studies that have attempted to address that, but in general, IV medications are much more likely than IM medications to cause adverse effects.
So in your medical opinion, using an intramuscular administration, is that likely to have less of a risk of side effects,
It should have fewer side effects with IM medication.
including respiratory depressant effect,
Yes.
including hypersalivation or vomiting?
Those I would not expect to be related. The vomiting may be related to the route of administration. The hypersalivation I would not expect to be related to the route of administration. But again, I don't know of any studies that specifically have addressed that.
You were asked about a study that involved a large amount of intubated patients. Do you recall being asked about that?
Yes.
In your review of the literature, has that situation changed from when that study was written?
Yes, as I think we talked about.
A response?
I think he asked specifically about this, Your Honor, on cross.
Overall,
So, as we talked about, this study was conducted by a colleague of mine, and the general, his impression when they conducted the study, and I think most of our impression is that as we have become more comfortable.
To be on the scope, he's talking about the study he did with his colleague. I asked about the 20.
response?
Judge, I can clarify this. I don't think he's referring to the study that he personally did.
All right, well, we do need to clarify which study he's talking about because the cross-examination was with respect to my recollection is the number was somewhere around 60% or something like that. That,
That would be the Oliva study.
hold on. I wasn't asking you a question.
Okay.
So I'll sustain the objection in part. We just need to clarify.
Sure. You're aware of the study I'm referring to, Dr. Hurd?
So I believe this is the Oliva study.
Correct.
Okay. In that study, there was a 60% rate of intubation.
And you were starting to talk about a colleague of yours participated in that study. Is
He
that
was
fair
the
to say?
investigator for that, the primary investigator for that study.
Was that a Dr. Cole
That was Dr. Cole.
listed as one of the authors of that study? Is that right?
Correct.
Levis got top billing, but Dr. Cole was involved as well. Is that right?
Correct.
Dr. Cole was Dr. Cole a former colleague of yours?
He was one of my medical students.
Okay. And you were starting to talk about that study. Is that right, Dr. Hurd?
Yes.
And what were you going to say about that and the intubation?
So that the impression of the team that performed the study was that as physicians got more comfortable seeing patients who had received sedative doses of ketamine in a pre-hospital setting, they recognized that those patients did not require intubation, that they would do well with observation.
And you yourself have never felt the need to intubate a patient because you gave ketamine. Is that right?
Correct.
Are you aware of whether there have been any ketamine fatalities at this blood concentration level?
I'm not aware of that.
Response.
It's certainly not speculation. He knows because of his research and his direct involvement.
All right. Well, I will find it's beyond the scope.
I asked you whether given the blood concentration would have been somewhat higher before Elijah McClain reached the hospital. I asked you if you believe that would be toxic. Separate question, do you believe that would have been a fatal dose?
Judge asked and answered.
I'm assuming it's foundational.
Yes.
All right, I'll allow it. Move on.
It would not be a concentration, a fatal concentration.
Even though technically it was what you would describe as an overdose, is that right?
Sustain.
Your use of the word overdose, you mean that to affect in any way your opinion of toxicity?
I'm sorry, I don't understand the question.
I heard you testify on cross-examination. This was what you would consider an overdose.
Yes.
Does that affect your medical opinion to a reasonable degree of medical certainty about toxicity or fatality?
No, this was not an overdose I would expect to cause toxicity or fatality.
Dr. Hurd, in your opinion, we saw the chart about certain amounts that would have or should have been given. Do you recall that chart?
Yes.
In your experience and your opinion, is it uncommon in the emergency department to overestimate a patient's weight?
Objection. Way beyond scope. And
No, I'll sustain that one.
Thank you, doctor. I don't have further questions.
All right, on behalf of Mr. Cichuniec.
No questions, Your Honor.
Any redirect?
Judge, that
Oh,
was my-
that was, okay, now I'm getting confused. It's apparently time for the court to take a break. All right, we're going to take our lunch break, folks. If you could be back at about 1:15, that'll give you about an hour and 20 minutes to take care of your lunch or whatever you need to take care of. Don't form or express any opinions or discuss the case even amongst yourselves. Do no independent research. Um, And avoid any press coverage. We'll see you in about an hour and 20 minutes. and 2806. Yes, we have the parties and counsel present. Anything before the jurors return? Okay.
And spell your name for the court reporter.
I'm Ljubisa Jovan Dragovic. That's Ljubisa, middle Jovan, last Dragovic.
And Dr. Dragovic, where are you from?
I'm originally from Montenegro in the Balkans, from former Yugoslavia.
Okay. Can you tell us a little bit about what you do for a living?
Well, I'm a physician specializing in forensic pathology and neuropathology. I'm currently employed in the capacity of Chief Forensic Pathologist and Chief Medical Examiner for County of Oakland in Michigan, with a population of 1.3 million people. And I was just a couple of months added another position as the Chief Medical Examiner for County of Macomb. This was by the decision of their government without much notice to me, but it's burdening me with another workload for a period, at least a temporary period of several months, from the population of 900,000 people.
And Dr. Dragovic, before you were in Oakland and before you got the new county added, where were you working before?
That was back 33 years ago. I worked for Wayne County, which is Detroit, Michigan. I served there in different capacities as assistant medical examiner, as a consulting neuropathologist, and for a period of 4 months, I was acting chief medical examiner back in 1988.
So in total, how many years have you been a forensic pathologist?
I think I'm pushing 38 years now.
And prior to becoming a forensic pathologist, how many years were you a neuropathologist?
Well, I was in neuropathology training for 2.5 years at 2 different centers in Canada, at Queen's University in Kingston, Ontario. And then my senior fellowship year in neuropathology was at the University of Toronto in Toronto, Canada. And then I practiced research neuropathology for a period of about 1.5 years. And before that, I was in training in anatomic pathology back at Queen's University in Kingston, Ontario. And before that, I was in general practice with my wife, serving an underserviced area in the Balkans for about approximately 11 months, not full 12 months, before coming to Canada and joining the Department of Pathology at Queen's University. And I graduated from medical school in 1975, so that puts it 48.5 years ago.
You beat me to my next question. Can you tell the jury just a little bit? I know you don't like to brag about yourself, so just tell them a little bit about your education. What makes you qualified to be here today?
Well,
Sorry.
my education, professional education, is in the area of anatomic pathology, for which I became board certified back in 1982. And then in neuropathology, which I became board certified by the American Board of Pathology in 1985. And in forensic pathology, which I got board certified in 1987 by the American Board of Pathology. So these are the basic qualifications. And there is a practically lifetime experience in trying to assist in sorting out things of public nature, because that's what forensic pathology is all about. Where forensic comes from Latin word forum, which is a place of public gathering. And in simple translation, forensic pathology is public pathology. So anything that comes to be an interest public is in the realm of forensic pathology.
Could you tell the jury any clue as to, over these almost 4 decades of service, how many autopsies you've done?
I honestly don't know because I don't keep the track of that. Would be thousands. I remember that when I was acting chief in Detroit, in Wayne County, for that year, that was 1988, I performed about 1,200 autopsies myself. That was an unofficial record for the continent at the time. I don't know, maybe some other people lost their mind and did as many as I did, but I had no choice because I was working with relatively small professional complement in a very busy place during the cocaine wars and other things that were happening there.
Would you estimate we're talking a couple thousand, tens of thousands, 20,000, any clue?
I don't know. Certainly over 5,000-6,000 cases, maybe 10,000 cases. But this is a lifelong of doing examinations, postmortem examinations, doing autopsies. So there is no way for me to give you an exact number. I'm sorry.
And do you still actively do autopsies today?
Yes, well, not today, but next Wednesday I'm on. And, whenever I'm on the schedule, there are 5 forensic pathologists in our agency, and I am the one responsible for everyone's work, but my colleagues and I share the roster and work kind of through the roster, depending on the daily caseload. Obviously, our caseload has jumped up from an average of 3 to 4 a day to about 7 to 8. Well, on Thanksgiving Day, I did 7 cases in the morning.
Can you tell the jury, have you ever testified in court before?
Yes, ma'am.
And have you been qualified as an expert?
Yes. I probably testified close to 1,000 times, maybe even more, because I worked in a very busy area of Southeast Michigan and in the 3-county area, and also wherever someone would call for assistance, like special prosecutors and things like that, elsewhere outside of my state.
Judge, at this time, I would move to tender Dr. Dragovich as an expert in the area of forensic pathology and the associated anatomical pathology and underlying investigations related thereto.
Board Dyer?
School defense was just as an expert in the area of forensic pathology, so I object to extending his knowledge.
Okay, response to the objection.
Judge, I think it's all within the area of forensic pathology. I don't have anything additional. I just meant in the surrounding encompassed areas of forensic pathology.
Based upon the record, the court will allow Dr. Dragovich to opine and explain in the areas of forensic pathology.
Thank you, Your Honor.
Dr. Dragovich, can you talk to the jury? How do patients come to you?
Well, actually, patients do not come to me because patients are living individuals. Patients are in the realm of clinical medicine. People who die as a result of their health problems or as a result of violence or trauma of other kind or unexplained and unknown or suspicious deaths. Those are the cases, and we refer to them as cases because patient is a person that is suffering from something. A dead individual is not suffering from anything anymore, but we still have an obligation to establish what happened, what the problems were, and to provide that. And by law, I mean, in my state, in my jurisdiction, I am obliged by law that mandates me to investigate death and provide, reduce my findings to paper and provide testimony if necessary about interpretation of the findings that I come across during my examination.
So when the cases come to you, your job is to investigate and try and figure out cause and manner of death. Is that fair to
That
say?
is correct. That is the basic requirement, the statutory requirement, at least in the state of Michigan. I'm not too familiar with the local laws here, but in the state of Michigan, I am required to do so, and I open up the medical legal investigation of death, and I close it, not only myself, but my co-workers that work for me, my assistants, my deputies, close the investigation when it's done, when the report is ready and provided for the public to utilize it any which way it may be needed.
When you are trying to work through a case and determine cause of death, what are we talking about?
We are talking in my line of work, in forensic pathology, we're talking to examining the body, the outside of the body and inside of the body, examining or learning about the circumstances that surround a particular death and integrating those through connecting the information from the circumstances to the anatomical substrate of death. That is the cause of death. That is something that can be demonstrated in the inside the body or on the outside of the body, on the surface of the body. That would be, for example, various types of wounds, whether from firearms, blunt force injury, sharp force trauma, or disease processes or degenerative changes affecting various organs. So when we are talking the cause of death, one is focused on identifying that physical finding affecting the tissues or organs within the body and documenting that and putting that forward as the cause of death. Cause of death is why someone died.
So as a physician who works on cases as opposed to patients, what are the things you look to help you inform and make decisions about cause of death?
The actual findings on the body and within the body, the medical records, if any, in existence, the information surrounding a particular death from anyone at the scene, and how are we organized? I have investigators who are specially trained because of their prior lengthy experience in being leading detectives, ranking detectives in major police departments, and they go to the scenes and document the scenes together with the local police by photographic representation. And before even starting a case, the examination of the case, we have on our screens everything that has been already processed through the information about the scene. And we have obviously the representatives of law enforcement, if needed, for the case at our autopsy area. So that is the process, and it is the routine. Obviously, each and every case on this planet that goes to any medical examiner's office is unique because that person is a unique person. And there are, although there are similarities throughout, there are multiple people dying of heart attacks. They're totally different individuals, and they have totally different things to take care of and to address. Same thing about the trauma. Someone may be a victim of blunt force injury, and then you have another 5 person similar to that, but they are unique, and their circumstances are unique. And anything that happens in forensic pathology is uniquely tied into a particular case. There are no statistical approximations.
Okay. Now, when we talk about manner of death, what does that mean?
Manner of death is simply how death comes upon a person. The circumstances, the physical circumstances. What happened? What happened out there? Even in the hospital, we have to investigate why a person died and what surrounded the particular death, because they may be dying from a natural disease process, or they may be injured in the hospital itself by stepping on the slippery floor or something like that, and being recovering from that, and that creates another aspect of investigation, if you want. So it is critical to know as much as possible about the circumstances that surround a particular death in order to make a reasonable conclusion and correlation with the findings, physical findings that you're presented with the body.
How many, are there categories of manners of death?
Yes, these are generally worldwide accepted categories, and natural death, natural manner that is natural, it reflects the death occurring as a result of degenerative processes from within our bodies. For example, heart attacks because of hardening of our coronary arteries, pneumonias, liver disease of any kind, kidney diseases, all kinds of processes and conditions that are within our body, not provoked directly by something from the outside of the body. That's a huge, fortunately, the largest manner of death category, the most populous. Then there is homicide. Homicide is the manner of death where death results from a purposeful act. Mind you, purposeful act, demonstrable purposeful act of someone, of one or several individuals, or as many individuals as they may get involved. So it is a broad category. Not every homicide is a murder. The murder is the legal definition that is rendered by the entities like district attorney's office, prosecutor's office, attorney general's office. We classify those deaths as homicides, and under those categories, under that category, there are all kinds of cases with subsets that can be addressed by actual peculiarities of any individual case.
And what other areas are there?
There is a category of suicide. It's a very narrow category. It's death resulting from purposeful act by self and self only. If anyone is involved beyond the victim, it is not a suicide anymore. It becomes a homicide for whatever reason, whether it's excusable homicide, justifiable, acceptable by the existing laws in a particular jurisdiction. It falls in the category of homicide. So it has to be purposeful act by self and self only. Then there is a broad category of accident. Accidental deaths involve the untoward effects of someone's acts or actions. For example, traffic fatalities generally considered accidents, unless a particular case demands the investigation of the actual happening, how this supposedly and reportedly accident occurred. So, for example, if you have a situation, someone is struck by a vehicle running at a relatively high rate of speed, and the driver failing to stop the car, would be considered an accident. But if this type of vehicle, this driver sees someone that he particularly or she targets and drives the vehicle by pinning them to the wall, or drives them down for a purposeful reason, then it's a homicide. A very simple, if you allow me to explain the comparison, discarding banana peel on the sidewalk is a careless act. Someone walks by, steps in the banana peel, falls backward, sustains head injury. 2 days later, they're dead. This is an example of accidental death. But if you place a banana peel at the doorsteps of the neighbor you hate, that's a purposeful act, then it constitutes a homicide. Accidental deaths are also deaths resulting from tornadoes, volcanoes, earthquakes. I would mention one, to God. I'm not particularly religious, but I had a case in Michigan where a man threw his arms toward the skies and said, "Come on, Lord, hit me if you can." Several seconds later, he was struck by lightning and brought to my office. So I recommend care in provocation. Sorry.
And the last category would be undetermined, right?
Last category is undetermined, and this is of particular interest because undetermined means I don't know. I don't have enough information about this. I don't have enough physical facts and evidence to put them together. And although in medical schools, we prepare medical students, and I went through that, and every physician went through that, to be able to know everything when asked a question. There are areas that we don't know. And in this line of work, by general philosophy of the work, we are able to say we don't know. Otherwise, in medical practice, vis-a-vis live patients, doctors have to show the ability to control and suggest and authorize and be an authority for the patient. And they must exude this omnipotence and an absolute knowledge. Although, only fools know everything.
So as a physician and as a forensic pathologist, it has to be frustrating sometimes to not know.
Well, it's always a challenge. But no one promised anything that would be easy. This is the area of work where people do not have in quite a few situations do not have a definitive answer, and their opinions vary. But you have to understand that opinions are not necessarily reflecting the absolute knowledge. Opinions are attempts to bridge a gap of the unknown. And we, as medical professionals, are always called to render an opinion. You have to have some type, or if you don't have an opinion, you say you don't know.
How important is it to follow the science when you're rendering opinions?
The closer to scientific evidence you are, the better it is, because you are that much closer to the truth. Is there absolute truth? I hope there is, but we are all trying to get to the bottom of it. Some with more, some with less success.
Okay.
It's how it is. That's the reality.
At some point, were you called upon to assist us with trying to get some answers in the Elijah McClain situation?
I believe that was in the beginning of October.
Yes.
That someone called me, and I don't know
Sure.
whether you did or someone from your office.
And are you compensated for your work?
In general, I am compensated by my salary. I'm not compensated myself for this because I'm on my county time. So you will be getting a bill for this from my county government.
And
They have a reasonable rate. It's $2.50 per hour prorated for 8 working hours in a given day. That was the decision of the Board of Commissioners of Oakland County back in 1997. They have not increased it. So that's it.
you need to talk to them about the rate of inflation.
I'm not the one who does those things. My focus is on my bailiwick, quite frankly.
Sure. So you get a salary, but your government will invoice and they will receive the invoiced fees.
Yes, and I hope someone will pay for the transportation.
Fair enough. So can you tell the jurors, when you were asked to confer, what sort of things did you, and well, let me back up. At some point, were you able to render some opinions in this case as to cause and manner of death without going into what those are?
Yes, ma'am?
Okay, so can we talk to the jury about when you have this situation where you're called upon to do this? You didn't do the autopsy, did you?
That's correct. I did not. Dr. Sina did.
Okay, and fair to say, the body is long gone?
I assume so. I believe that the body, the disposition is by cremation, I think.
Mhm. And in this case, in fact, the heart was gone too, correct? Oh, do you know?
Um, I don't know what particular, I remember that some of the organs were harvested at the time. Mr. McClain was on life support still. Heart was there, the lungs were there, heart was examined. I don't know what happened with the heart, with the tissue of the heart. I
Okay.
have no idea.
Let's walk the jury through your understanding based on your investigation of what was investigated and what the information was that you could distill from the autopsy.
Well, the autopsy findings were documented in the first report. There was finding of anoxic encephalopathy, which was an obvious finding, non-compatible with survival.
I'm going to stop you there because we're not forensic pathologists. What is an anoxic encephalopathy?
Anoxic encephalopathy is essentially brain death. The lack of or the deprivation of oxygen supply render the brain tissue dead, and that's what we refer to as anoxic encephalopathy. And Mr. McClain suffered anoxic encephalopathy at the time, shortly after he was admitted to the hospital, or that was documented at the time. It more likely started over some time prior to his admission, but at the time they examined Mr. McClain, they concluded that he was brain dead.
Okay, so we know there was an anoxic encephalopathy. What else could you distill from the actual autopsy?
I have to explain that the anoxic encephalopathy was exemplified by changes of the brain, by necrosis occurring in Mr. McClain's brain. The other findings were in the lungs. The lungs clearly demonstrated via the microscopic slides and by description and by the photographs that we supplied, the evidence of massive aspiration of likely regurgitated gastric contents at the time. At the time I saw it, I subsequently received more information, and that turned out to be the major anatomical finding, major anatomical substrate, as I talked about, that connected directly to the necrotic brain. Because without capacity to breathe, with the impairment, such severe impairment of breathing, that this resulted in a heart attack, cardiac arrest, stoppage of the heart, and resulted in complete supply, or lack of supply of blood with oxygen to the brain. And that was what happened there. That's very simple.
Okay.
Now, there was also an issue of reported narrowed left anterior descending coronary artery. That's the branch of the left coronary artery that supplies the front wall of the heart, and the outer side wall of the heart. This was described, it was not photographed, so I cannot comment any further on that, and the significance of it. The heart weight was normal, in the normal range. It is, I believe, 165 grams. Oh no, 265 grams. which would be the normal range for the age of this young individual. And,
Let me ask you about the narrow lad that was reported. And you can't comment more because you couldn't study the heart, correct?
correct, I did not have anything
Hold
more.
on, hold on.
Is that,
Yeah, there's no objection. If, just so I can make sure that I'm alerted, and if you can either stand up or pull the microphone closer. And what was the specific objection leading?
Yes, sir.
All right,
Judge, I would simply say it's foundational, but I can reword it.
go ahead.
Dr. Dragovich, with the respect to the narrow lad, you said that you can't comment more. Why is that?
I don't have any evidence. I need evidence. You see, the forensic pathologist always needs some factual evidence, something that is tangible to interpret it. Otherwise, it's more in the realm of opinions, but opinions should be based on evidence too. Off the cuff opinions are not the best advice in this line of work.
Let me ask you, if you had been doing this autopsy and you had concerns about the lad, what would you have done?
Photograph, photograph anything that is departing from normal, and then sampling the area extensively if there was an impressive finding of significance that gave some additional gross indication. It's there is a variation in approach. I understand that my colleague, Dr. Sina, saved the heart informally for examination, but after that preservation, there should have been some photographing and documenting if there was something of significance to document.
We've heard about a cardiac pathologist. Is that something you might do?
Well, cardiac people with special interest in cardiac pathology are there among us, both forensic pathologists and academic pathologists, and that's always available for some peculiar finding or peculiar information needed. But I think the bottom line, the gross preservation, the gross appearance of the heart, the photographs would have sufficed.
Mhm. If there was a error in slicing portions of the heart, talk to the jury about that. We don't do forensic pathology. So what are we talking about these slices of the heart and slides?
Well, if you have an organ like a heart and you want to sample the tissue of the myocardium, the heart muscle, or the blood vessel that feeds that muscle, you take a sample perpendicularly to the flow of blood and you put it in a cassette. You prepare it in such a way that it is embedded in paraffin block in order to create a glass microscopic slide. In the process,
And doctor, could you pull the microphone with you? Just,
oh, I'm sorry.
that's okay.
In the process of doing that, sometimes if you have like a little artery, it's like a tube that you cut and place perpendicularly in the plastic cassette. You put the cassette in formalin and send it out to be processed as such. It can flip within and it can get embedded erroneously. When you get your microscopic slide, you can say, well, this is erroneously embedded, that there's no good opportunity to evaluate it. But then you can call them and say, hey, let's flip this over. It may be more difficult if you're sending samples to some lab outside. In my agency, I have a lab at the premises in my building, and I can consult with histotechnologists anytime about that if that happens. So there is a way to remedy that. But I don't know. I understand from the slide that I looked at, it's still the same slide. It was not reoriented. So I can't conclude anything on that.
Okay, so we can't conclude anything on the heart. Let me ask, for a cardiac pathologist, is taking a class on the heart in med school unusual? Does that make you a cardiac pathologist, or do all forensic pathologists do that?
No, a forensic pathologist is expected to know the basic issues about the heart. And like I said, in any special situation where there is a peculiar case, then academic centers are around, and there are people there who focus all their life and all their career of evaluating heart specifically in the realm of pathology. So they can be contacted and ask for advice, whether they are called cardiac pathologists, because there is no special certification by the American Board of Pathology for cardiac pathologists. It's just a subset of anatomic pathology and forensic pathology. Yeah.
So let's talk about what you could conclude versus what you could not conclude. Tell the jury, what was your conclusions about the cause of death as to Elijah McClain?
Mr. McClain died as a result of anoxic encephalopathy that was brought about by inhalation of regurgitated stomach contents. That he experienced that over a substantial period of time during the confrontation. There was physical confrontation, and he had a mask on, and there was evidence on the mask itself of regurgitating, of his throwing up. In the process of that scuffle, he was obviously inhaling some of these materials that he brought up from his stomach under pressure, because he was subjected to pressures. And once those particles from the stomach that are rich in hydrochloric acid get into the air sacs or terminal bronchioli, terminal tubes that we breathe with, once they are in there, it's the acid that breaks down the respiratory membrane, the inside, it breaks down the capillaries walls and results in bleed. And that's why those leopard spots are shown in the lungs. They're kind of brownish, purple, whatever. They were red, dark red. That's the result of the blood coming from damaged air sacs and bronchioli, which are the terminal tubes that connect to our air sacs with which we breathe, because that's where the oxygen exchange and the carbon dioxide exchange occurs in our lungs. So once that function of the lung is eliminated, it gets to be a progressive hunger for air and struggle. And this was reflected over several minutes where there was moaning and groaning and continued expectoration or vomiting of stomach contents.
And
So-
what was the manner of death?
Well, the manner of death has to be carefully considered. As I pointed out, if you are trying to figure out and interpret the manner of death, you have to look for sentinel of purposeful or purposefully rendered deadly injury. I did not find evidence of that.
Judge, he's allowed to give his expert opinion about the manner of death and what supports it.
All right, I'll allow the doctor, of course, to testify in terms of medical versus legal perspective on his findings of manner of death.
Certainly. And doctor, is everything you're testifying to under your medical opinions?
It is a scope of medical, but also the medical legal understanding, because the manner of death has to have certain determinants before it is offered, before it is proffered to the public. And if there is evidence of purposefully inflicted or purposeful injury rendered upon physical evidence.
Instructed to him now, instead saying he was going to explaining to the jury what purpose or intent is under this medical
And Judge, I think what he's trying to do is explain that this is a public health record, but we can ask him to clarify that.
Yes, we'll need to because we don't want to blur the lines between
Sure.
medical versus legal.
Sure. Doctor, you're not trying to tell this jury what any jury instructions of the law in Colorado are you?
No, ma'am, I am not familiar with that.
Are you?
I am familiar with the determination of manner of death, and I'm trying to point out why I believe that this was accidental death, because there was no demonstrable evidence of purposeful act by anyone rendering death.
interior subjective intent. Very honest.
Judge,
Again, from, I'll
Yeah.
allow the doctor to testify based upon his medical opinion of cause of death and here specifically manner of death.
so doctor, when you're filling out a death certificate and you're making a determination of manner of death from your training, is that what you're explaining to the jury about why you conclude accidental death?
That is exactly the case.
Go ahead.
So my conclusion was that this was accidental death. And I explained what accidental death entails. It's the untoward effect of someone's acts or actions upon the person.
And doctor, did you also come to a reasonable degree of medical certainty as to whether ketamine played any role in the cause of Elijah McClain's death?
I did not see any evidence that ketamine played any role in the demise of Mr. McClain.
And in the thousands of autopsies you have done, have you ever seen somebody come into your morgue that suffered a ketamine death at this level? Judge, it goes to his expert opinion and it's not speculation.
We'll need to clarify whatever the term "at this level" means, because I certainly don't understand it.
Let me ask, do you remember what the level of ketamine in Mr. McClain's blood was?
I believe it was 1.4 milligrams.
Okay. And in your almost 4 decades as a forensic pathologist, have you ever had somebody that you've done an autopsy on that has died from that level of ketamine?
No, this is a therapeutic level in general, but I cannot proffer here any experience that is comparable to this particular case. As I indicated, each and every case is different, and there are tremendous peculiarities, and one has to be able to assess all of them as best as they can. I cannot assess the role of ketamine in the first place because I have no evidence beyond the level, and the level is therapeutic.
So the jurors have heard this conversation about acidosis. Can you explain to them the difference between lactic acidosis, metabolic acidosis, and stomach acid?
Well, lactic acidosis is a buildup of lactic acid as a result of muscle activity, strenuous muscle activity, running, biking, boxing, engaging in high impact sports, playing tennis, playing football. That is the normal response to strenuous muscular exercise. And it is, if one goes beyond the certain level, it may be detrimental. It may cause fatigue. It may cause render someone unconscious and whatnot. So that's lactic acidosis coming as a result of the development or production of lactic acid in the muscular system. The overall metabolic acidosis can be related to lactic acidosis, but it can be a totally different, various other considerations as a result of those conditions. Acid in the stomach, gastric acid, is completely different. Gastric acid is not lactic acid, it's hydrochloric acid. And stomach is a hollow organ that contains and secretes hydrochloric acid in order for us to digest our food that we eat. That acid can only go out with the gastric contents. That has nothing to do in any way with lactic acidosis. So it's not, the stomach does not produce more hydrochloric acid when someone is in strenuous physical exercise or in a fight or something like that. So there are mangoes and papayas mixed up with figs and oranges. So, you have to be careful about that.
So if I did a 2-a-day football practice and I vomit, is that lactic acidosis or is that stomach acid?
It may be one or the other, but it cannot be mixed both. If you vomit because your diaphragm is hypertense and intentionally working up and down because you're trying to breathe deep to counter lactic acidosis, that will happen. You will have the opportunity to vomit after that to relieve yourself because the diaphragm movement has upset your stomach. But hydrochloric acid is the acid that is contained within the stomach, and the stomach produces it and it gets neutralized. It's not affecting the rest. The rest of the body. So there is a distinction between the two.
Sure. And doctor, you were able to review some of the body-worn cameras in this case, correct?
That's correct.
And can you tell this jury, from your perspective, where you think Elijah McClain was aspirating? When and where?
Well, he was aspirating during the confrontation, the active confrontation, even before he was handcuffed. During the process of that physical subdual, he vomited on several occasions, and there is evidence on his ski mask of vomitus. This became a problem as he was getting more hypoxic because of that effect, because of aspiration, to the point that when he was handcuffed, he was continuing to exert physical activity by kicking. That was the time where the first sign of brain receiving less oxygen, because I believe at that time he was thrashing. He was not doing any purposeful kicking or something, and he still held him down because they believed probably that he was trying to fight, but he was actually in extremis, and he was thrashing at the time.
Did you see at any point on the body-worn camera times when you believe he aspirated once EMS had him, once the paramedics had him?
He had vomitus and mucus coming out of his mouth, of his oral cavity. Whether I could not see what was in his nostrils. If he had this coming out of his nostrils too, he might have been, but I don't know. That is just an assumption but I could not discern whether there was something coming from his nostrils. Definitely from his mouth.
Okay. And at that point, if they had suctioned him, is that what you would do for that?
See, they will do what they are supposed to do. The first responders to do the suctioning and try to intubate. Whether the intubation would have been remedial is up in the air. I'm not clairvoyant. I can't foresee anything beyond what I see with my eyes.
How about when you're doing active CPR? Can people get gastric contents into their lungs?
Sure. They can, it depends. It depends what CPR, cardiopulmonary resuscitation, is a process where you're trying to bring someone back who has experienced at that point a heart attack, a cardiac arrest, simply stoppage of the heart. So whether you are in the process of getting the heart activated, reactivated, and at the same time pressing on his stomach, because stomach is not too far from the heart. Actually, they're touching each other right there. You can push contents of the stomach up the esophagus, up the gullet, to the point where they can reach the voice box and get into the trachea, into the windpipe, and down into the lung. Now, for that, for active inhalation, you have to have at least some attempt to breathe and some function of the lungs. You cannot, if someone is dead and there is no successful revival and lungs are not functioning because the person is not breathing, and there will be no aspiration, but there will be evidence of forced gastric content up in the oral cavity, in the nasopharynx, but not deeper down in the lungs, because for the aspiration to occur, you have to have active suction by the lungs. And if that's there, that can happen.
Okay. If I could have just a moment. Thank you, Doctor. I don't have any further questions for you at this time, but others may.
You're welcome, ma'am.
All right, direct examination on behalf of Mr. Cichuniec.
Good afternoon, Dr. Dragovich.
Good afternoon, sir.
Would you mind if we could maybe just take a,
No, not at all. We can totally stretch.
after lunch, I think it's sometimes rough.
It's just so worthy reading kids. I'm going to.
Yeah.
All right, let's try to get restarted. I call those TV timeouts. Relatively short.
Doctor, I just want to kind of expand on some questions that Ms. Bagan was asking you. I'm hoping my examination will be shorter in length than hers was, but I'm sure, as you are familiar, lawyers often make promises about time and then often struggle to keep them. So I will do my best. You testified and told this jury a little bit about your extensive experience and background as a forensic pathologist. As part of your work in forensic pathology, in addition to doing autopsies, are you often called upon to review autopsies that are performed by other forensic pathologists?
Yes, sir.
Okay. And um, when you do that, as you were asked in this case, are there certain limitations of that review that you have that you wouldn't necessarily have if you had conducted the original autopsy?
Well, they may or may not be. It depends. It varies from case to case. And sometimes I'm very impressed that people will do a lot more than I would have done in any such case. But it's quite variable, and it's not the amount of work. It's mostly when it comes to interpretations and to connecting the dots on certain findings where they may need assistance.
Okay. If there are limitations that are presented by that type of review, what are some of the limitations that you've run into?
Not preserving the evidence, not taking photographs. There was an old school in forensic pathology that was a defensive type of school where people who ascribed to it would not take photographs because that would offer them to impeachment and criticism because of the discrepancy between the photograph and the claimed finding and things like that. So there are various problems and issues, and you have to remember that forensic pathologists are human beings, and they're making errors just like anybody else. Only people that don't do anything do not make any mistakes. But mistakes are made, but mistakes have to be checked out, retraced, and corrected, because if you set them aside, you are not doing the right thing.
Okay. So you've talked about photographs as being one way to document evidence from an autopsy. What are some other ways in which someone performing an autopsy can document that autopsy?
Generating microscopic slides, because that's another physical evidence that one can rely upon without any subjective variation. And if you look at the slide, if 3 other or 5 other colleagues in the field look at that same slide, there should be a reasonable agreement, because the morphology is not variable. Now, the interpretations may be variable, and that comes as a given, because we're all human beings.
Okay. If you were performing an autopsy and you were concerned that a certain organ of the body may have caused or contributed to the death of the person who you're conducting the autopsy on, what would you do, or what is standard to do with that organ?
Photographic documentation and extensive sampling of that organ.
And extensive what, I'm sorry?
Sampling, tissue sampling for the purpose. But extensive photographing if something is departure of normal. Anytime anyone sees something that is not normal and usual, it deserves to be photographically documented. And it's not like in the olden days that you take 35 millimeter cameras. Nowadays, people have digital photography available. Everything is a snap of the fingers, and you can immediately project it on the screen and show it to someone in on the other side of the continent or in a nearby institution, and they can assist with it if assistance is needed. Of course, sometimes people hate to ask for assistance. So again,
Could you
human nature.
Sure, and I appreciate that. Could you also, if you thought it was important, could you preserve that organ?
Well, yeah, the laws generally, I don't know specifically the laws in this.
All right, rephrase.
Regardless of the local law in the community, as a forensic pathologist and a trained forensic pathologist, if you have concern that an organ of the body may have contributed to or caused the death of somebody, could you preserve that organ?
Yes,
Is it fair to say that another way you can document evidence is to write a report?
well, yes, writing a report is the standard operating procedure, but the report is carrying a degree of subjectivity, and it has to be matched and authenticated by and substantiated by photographic documentation or by microscopic slides documentation, because those are the pieces of evidence.
You've talked and testified about two terms of art in forensic pathology, which is cause and manner of death. Do you recall that?
Yes, sir.
Okay. In a autopsy report, is it uncommon for someone to also list something as a contributing factor?
If there are findings that are clearly indicative of contribution to the disease process or injury process or the healing process or whatnot, yes, by all means, that should be the way to document it.
Okay. As part of your review of this case, did you review Dr. Sina's original autopsy report from November of 2019?
Yes, sir.
Okay. On Dr. Sina's autopsy report, he lists cause of death is undetermined, manner of death is undetermined, and then he lists a third category, contributing factors. Do you recall that?
Yes.
Okay. And he lists under those contributing factors intense physical exertion and a narrow left coronary artery. Do you recall that?
Yes.
Okay. When you reviewed that, what did you interpret contributing factors to mean in that report?
Well, the reference that Dr. Sina made to exertion is reflecting the mechanism of onset of some of the consequences, but that was only a hint, there had to be a connection to the finding of anoxic encephalopathy and the finding in the lungs that were pretty striking and pretty well documented.
And then he also lists as a contributing factor a narrow left coronary artery. What did you interpret him to mean by that?
I interpreted it as an anatomic variation, and that was it. There was nothing more about it said other than the fact that it is narrowed.
Okay. As part of your review in this case, did you also have an opportunity to review both the report issued by Dr. Roger Mitchell and the report issued by Dr. Mitchell on June 21st, 2021, and the second report authored by Dr. Sina on July 1st of 2021?
Yes, sir.
Okay. Now, in both of those reports, language of complications of ketamine administration were employed by both Dr. Mitchell and Dr. Sina. Do you recall that?
Yes.
What does complications, when a word like complications is used in an autopsy report by a forensic pathologist, what does that mean?
Well, a complication is something that is developing after some primary injury or disease. So if someone has a heart attack, for example, the myocardial infarct ruptures the wall of the heart, and there is blood coming out into the pericardium, and the person dies several days later of cardiac tamponade. That would be the complication of a heart attack. So there has to be some happening, some condition, some injury that will be followed up by complication.
Okay. I want to talk to you a little bit more about this left anterior descending coronary artery, or what's been referred to as a LAD. I think you testified under Ms. Bagan's direct examination that essentially there were no photographs that you were able to review of that. Did I understand that correctly?
That is correct.
And I think you testified, so based upon that, you can't really comment on the LAD?
That's right. I indicated that in order to interpret something, you have to have some fact. And that's the calling for a forensic pathologist.
When you, and I appreciate in order to comment something, you have to have a fact. Does that mean that you don't have enough information to either rule it in or rule it out?
It's a moot point in my view, because I can't say anything one way or the other. If it is reported, then the person that reported it it should be the source of information. But if it's not documented, then I cannot take it as verifiable, as substantiated by any fact and evidence.
Because there was no evidence, were you able, in your medical opinion, to rule out the possibility that a narrowing LAD contributed to death in this case?
Like I said, I can't rule anything out or rule anything in. I mean, about what I don't know. And there are a lot of things that I don't know. So I'm not talking ever about what I don't know, because it's an ocean.
That it is, doctor, that it is. You indicated, and I think on direct examination, that you didn't see any evidence that ketamine caused the death of Mr. McClain. Is that correct?
That is correct.
Can you tell this jury why? Well, let me ask you this. What type of evidence would you expect to see if you were to conclude that ketamine caused the death here?
If there was ketamine intoxication, then you would first go with the lungs and see that the lungs were filled with fluid. The lungs were not filled with fluid. The lungs were filled with inflammatory response to the inhaled regurgitated gastric contents, and that's that takes that out. So in any case where there is a suspected intoxication by the type of medication that is kind of depressant, that has kind of depressant on the central nervous system, there will be effect. If it is a significant effect, a significant outcome of that intoxication, there will be accumulation of the fluid in the lungs, as we call it, neurogenic pulmonary edema. Because there is depression of the central nervous system control of breathing. This man, unfortunately, had inhaled already so much of the regurgitated gastric contents that the pulmonary edema would not have been or is not appreciated in the sections that were taken. I did not see that evidence. That's much for the type of effect on the drug. Now, there was talk about idiosyncratic type of thing, where that would be an allergic reaction, a fulminant allergic reaction. In those instances, there will be probably some detail of eosinophilic surge in the mucous membranes and things like that. But I don't know. I did not see any evidence of that.
So on your review of this autopsy, did that include photographs of the lung?
Well, it did include photograph. the gross photographs that were made, and it included the microscopic slides that I looked at.
And did you see any evidence of this pulmonary edema that you would expect to see with the ketamine?
No, the dominant picture was reaction to inhaled gastric contents, which was manifested. This is, mind you, this is 3 days after the actual happening, because there was a survival in the hospital, and there was a florid reaction of multinucleated giant cell reaction, a granulomatous reaction to those, and that was the overwhelming picture in the lungs with other inflammatory process.
Okay. And I think we've heard some testimony before about those giant cells, but can you remind the jury, what significance do the giant cells present on microscopic examination of the lungs?
They're not specific to the lungs.
And doctor, if you could move the microphone over. Thank you.
I will, thank you. I'm sorry. The multinucleated giant cells are the sign of granulomatous reaction, meaning that whatever is brought in the tissue, any tissue of our body that is foreign to it, that cannot be dissolved by the activity of enzymes or simple inflammatory reaction, then you will have multinucleated giant cells forming, because they are supposed to engulf those big particles. So if there is a fragment of a food from the stomach, there will be a cause to form the multinucleated giant cells. If there is a piece of meat, a piece of vegetable or something like that, those bigger pieces that cannot be, that are not either bacteria or microorganisms that we generally fight with our white blood cells. So that's why it is a granulomatous inflammatory process, because it's characterized by these epithelioid cells that merge together to engulf the things that we see it in the lungs with other conditions, but this is the telltale sign that they are reacting to some foreign material that is inhaled.
And so just to clarify and to put a finer point on it, because I certainly am not a doctor or have that medical knowledge, is what you're describing essentially these large cells are consuming the aspirate material that are in the lungs? Is that what's happening?
Yes, and they cannot, since they cannot process it immediately, they're multiplying and forming in attempt to wall it off. This is the living body's reaction to that.
And staying with kind of that aspiration theme, once an individual has aspirated, in other words, once they've breathed back in stomach contents into their lungs, can that aspiration be reversed by suctioning?
The aspiration that reaches the end of the respiratory tree, that reaches the end tubes, the bronchioles and air sacs, cannot be removed. The cleaning of the windpipe is possible. Cleaning of the branches of the windpipe is tacky and less. I mean, I would leave it to a pulmonologist or to the pulmonary surgeon, a respiratory specialist. But beyond that, beyond the bronchioles, you can't suction anything. They are entrenched there and they're locked in there, and there is a chance, if the amount of aspiration is relatively small, there will be local inflammatory process and that heals over time. But if there is much more aspiration that takes both lungs out significantly, then it's not survivable, and then it's not remedial by standard operating things in the hospital setting, if you want.
Dr. Dragovic, just to clarify some of your earlier testimony too, were you able, based upon your review of this case, both of the The medical records, the body worn camera footage, and all the records that you had reviewed to include the various autopsy reports from Dr. Mitchell and Dr. Sina, and the microscopic slides prepared by both of those individuals. Were you able to form an opinion to a reasonable degree of medical certainty as to whether or not ketamine caused or contributed to the death of Elijah McClain?
Yes, I don't believe that it had anything, any effect in this situation.
1 second, Your Honor. Doctor, thank you very much for your time this afternoon. I don't have any further questions.
You're welcome, sir.
Any preference whether to start now and take a break in about 20 minutes, or take a break now and you can get started with your examination after a quick break?
Actually, now would be a nice time for a restroom break.
All right, let's do that, because I expect the cross-examination will take a little bit of time. So won't form or express any opinions, don't discuss the case. It appears the jurors are just about ready to come back in, so the court will recall 21 CR 2800 and 21 CR 806. Looks like we have everybody here. Dr. Dragovic is on the witness stand, so they should be in just a moment. Jurors entering. Jury is returned. Please be seated. The parties and counsel are present for 21 CR 2800 and 2806. The doctor is on the witness stand, still under oath. You may begin your cross-examination.
Good afternoon, Doctor.
Good afternoon, sir.
I'd like to start talking about your opinion on what caused Mr. McClain's death. You indicated that it was clearly caused by a large volume aspiration. Is that correct?
That is correct.
And that large volume aspiration, that stuff in his lungs, caused Elijah McClain to have a respiratory arrest, right?
Yes.
And a respiratory arrest, is that when you stop breathing?
Yes, and then you stop your heart as a result of lack of oxygen.
Well, that was going to be my next question, Doctor. In your opinion, to a reasonable degree of medical certainty, it's pretty clear that Elijah McClain's lungs stopped first and then his heart.
In my view,
Now, the autopsy findings in particular that support your view are that there's a large quantity of gastric contents inside of Mr. McClain's lungs, right?
yes.
And by gastric contents, we mean there's like food particles and stuff in there?
Or whatever was in the young man's stomach at the time. Food, maybe some juices, some fluid, or mixed with hydrochloric acid, obviously, because that's the secretion of the stomach mucosa to digest that food.
So it was that red emesis or vomit that was inside of his lungs?
So whatever the color exactly it was, I'm not really clear what exactly the color was of the emesis, but the this is the material that he inhaled as a result of regurgitation from the stomach.
Well, Doctor, I mean, you testified a moment ago that you were confident that Mr. McClain aspirated the material that was inside of his mask. Did you not look inside of his mask to see what color that was?
Oh, there was evidence of vomitus on the mask, but I did not try to decipher what exactly it was. I was associated the evidence of vomitus on the mask as early beginning of aspiration at the time.
And to be clear, you haven't actually viewed the mask yourself, have you?
That's correct.
Did you view any photos of it?
If there were photos provided, I don't remember exactly. I remember seeing the mask somewhere, but this was 2 months ago when I reviewed the materials.
Okay. Now, if somebody goes into respiratory arrest and they're not breathing, is it inevitable that they will go into cardiac arrest not too soon after?
They will go fairly soon as the respiratory arrest is progressing. In this type of situation, respiratory arrest can be the result of some other situation where its onset is sudden, not a continuum, because Mr. McClain had been in a continuum over a period of minutes of actually being subjected to aspiration of his regurgitated gastric contents.
Yeah, you mentioned that this had been happening over the course of, well, it's actually what, about 14 minutes or so?
Well,
between-
14 minutes is the whole stretch, but the early would be sometime there when he still had the mask on with the physical encounter with the police.
And between that point and when he gets the ketamine, his condition is pretty consistently deteriorating, right?
That is correct.
And that's pretty obvious just from looking at the video, isn't it?
Yes, sir.
And when we say his condition is deteriorating, in particular, he's exhibiting signs that he's acidotic.
Well, we are assuming that he is acidotic, and I don't think that there is any reason to set that aside because he was involved in a violent encounter. But we did not have any measure of his state of acidosis. However, we have the measure of his compromised breathing, and that's to me, that's more significant than, I mean, you get acidosis one way or the other, lactic acidosis, because of enhanced strenuous exercise or physical encounter as he was subjected to.
And Doctor, I appreciate that you're foreseeing exactly what the next question I'm going to ask is, but if you can, please try and just answer the one that I'm asking.
I didn't, I just get carried away, I'm sorry.
I was going to ask about those signs of problems with breathing, because we see Mr. McClain vomit on the video, right?
Yes.
And we can see in particular, right before and after the ketamine, that his breathing is very labored, and then it's really distressed on the gurney.
Well, I would say that he is grunting, and that was, to me, that would be the sign of difficulty breathing. And also the trashing earlier that occurred would be the first sign of onset of hypoxia, which was interpreted by him being uncontrollable.
Now, I want to focus on what we can observe medically, because you'd agree with me, Doctor, that you don't know what's going on inside the heads of the police there, right?
Absolutely not.
So it's normal, though, for somebody who is hypoxic or acidotic to move around to try and get better breaths.
Yes.
Now, I'd like to talk a little bit about your opinions regarding ketamine, if I could. On direct, you mentioned that you're confident that there's no sign of an idiosyncratic reaction to ketamine in this case. Is that correct?
Not that I have seen it.
Yeah.
Or that would be proffered by direction in some evidence that existed.
And you also indicated that there's no sign that Mr. McClain had an allergic reaction to the ketamine, right?
Yes.
And then you indicated that you're also confident that Mr. McClain didn't have ketamine toxicity or ketamine poisoning. Is that right?
Well, because that generally reacts in or results in neurogenic pulmonary edema.
Again, you figured out the next question I was going to ask, is that you're confident there was no poisoning or there was no toxicity from it because there's no pulmonary edema evidence.
Yeah, yeah.
But doctor, long before ketamine reaches those crazy high levels where it's toxic or poisonous to somebody, it does have other anticipated effects on someone.
Well, it's a sedative, and it also has some dissociative effect and some hallucinogenic effect.
Exactly. So one of the things that it does is it has a powerful sedative effect on somebody.
Yeah, I mean, that's why it is used in clinical medicine, yes.
And it also has some well understood side effects, like, for example, it causes vomiting.
If it is intoxication, yeah. But I can't comment on ketamine causing vomiting in the situation where there is a continuum of vomiting non-ketamine related.
And doctor, my question is just about known, understood side effects of ketamine.
Well,
There.
yeah, reported, yeah.
Yeah. So that's well understood in the literature. Ketamine
Yes.
causes vomiting.
It can.
It's also well understood in the literature that ketamine can cause respiratory depression.
Yes, in certain circumstances, certain individuals. It does not cause vomiting in everyone because everyone would be puking in the OR being given a ketamine, and that doesn't happen. So it's sometimes observed, yes.
Yes. And specifically, the times that respiratory depression is observed, it is more likely to be observed the higher the overdose given to a patient.
Again, you're pushing me into the realm of clinical medicine. I have no experience giving ketamine to patients because last patients I treated was about 46 years ago.
Okay. So fair to say that that specific question about whether increased doses increase the rate of respiratory depression, that might be a better question for an anesthesiologist or for a medical toxicologist?
Absolutely.
Okay. Now, if somebody is acidotic or hypoxic, that person really needs to breathe well in order to recover. Is that fair?
Yes.
In fact, those patients often need supplemental oxygen in order to help recover.
In those settings, in settings where supplemental oxygen is available, but I mean that's in theory.
Yeah.
Yeah,
There are
I
ways-
agree. Yeah.
That really good breathing, that increased oxygen, that helps the body to help clear acidosis as well.
Oh, it is the mechanism for clearing acidosis if there is no obstruction or some interfering situation. Absolutely. We breathe deep when we run. We increase the frequency of our breath, of our breathing when we run or when we play high impact sports or whatever we are doing physically, carrying bricks or unloading bags of cement or something, whatever comes to us.
You mentioned one of the things that can prevent somebody from breathing well to clear that acidosis or hypoxia is if there is an obstruction in their airway, right?
Yes.
If somebody is unconscious from a sedative like ketamine, that can prevent them from clearing an obstruction that's in their airway by coughing.
Well, in theory, yes, but I'm not sure that it is applicable to this situation because in this
Well,
situation,
doctor, sorry, I'm not asking you about your opinion in this situation. I just want to establish some
in general,
baseline understanding.
okay, yeah.
Yeah, somebody who's sedated, it's hard for them to clear their airway.
Yes, I agree.
In addition, somebody who is sedated is more likely to breathe in whatever substances are in their mouth and aspirate further.
If the airway is not protected, yes.
Yeah, if their airway is not protected and it's full of material in their mouth or nose, it's easy to breathe it in.
Well, you impair, if you're unconscious under those circumstances, you impair your swallowing control. And then everything goes right into the airways.
I assume that that can happen pretty quickly if you're already unconscious.
Well, if you're unconscious and if you're in a situation where, or in the position to allow the gravity to take the materials from your oral cavity, that can happen very fast.
And it can be either the gravity that pushes it down, or it can be the suction of taking in a breath.
Certainly, if there is an air hunger, if it is a reaction to greater demand to oxygenate, yes, that's possible. Yes.
I'd like to talk a little bit now, Doctor, about what you said about manner of death, which you poetically described as how death comes upon a person. Now, my understanding of your interpretation of homicide is that it is only classified as a homicide under your rubric if there is a purposeful act, a demonstrable purposeful act by someone else. Is that correct?
That is correct.
And so an accident would include, I think you said, untoward effects of someone's acts or actions. Is that fair?
Correct.
So under the classification that you're using of homicide and accident, is it fair to say that no matter how negligent someone's actions were, if they weren't purposeful, you would classify it as an accident?
Objection calls for a legal conclusion.
I'll allow counsel to rephrase. Let's strike the last question.
So no matter how irresponsible somebody's actions were, if they weren't purposeful, in your mind, that would be an accident.
Yes, because it's analogous to someone that is under the influence of alcohol, hitting someone on the road, and it's classified as accidental death.
Again, you wrote my next question for me. So, for example, if you had a driver who was drunk as a skunk, driving 150 miles an hour through a residential neighborhood, as long as they did not intend to hit someone, it would be an accident.
Yes, sir.
Now, in your report, you wrote that all of your opinions are expressed within a reasonable degree of medical probability or medical certainty. Why is that important for someone in your position?
Well, to reflect that these statements are taking into consideration the facts in evidence and the facts that are not in evidence. This is the kind of ultimate sorting out of what is there, what is not, and what the conclusion is about.
And I'd like to talk about some of the materials that you were provided in order to do your review in this case. Did you get all the materials that you relied upon from the defense attorneys?
I believe so. That was the only source.
Did they send you one batch, or was there a back and forth where you asked for additional materials?
I didn't ask for additional materials. They sent me a lot of materials on an external drive, together with photographs and everything, and then they sent the microscopic slides, and then they kept sending additional information as it came out, I guess, because some of these infos came at a later date. Some transcripts from the testimonies from some other trials.
So it sounds like they provided you with a number of different block packages or series of materials.
The critical material came in a hard drive, the external hard drive. The transcripts from the report from the previous proceedings came in some type of sequence from time to time. But this all started the first week of October, I believe, or second week of October.
Okay. Did you feel like you were missing any materials that you needed to make your judgments to a reasonable degree of medical certainty?
Not that I can think of, no.
Did they deny you any materials that you asked for?
I didn't ask for anything. I'm sorry. Maybe I don't know what their reaction might have been, but I did not ask for anything else. I had plenty of material to rummage through.
Now, I wasn't sure if I heard correctly your testimony on direct about heart photos. Did you testify that gross photos of the heart would have sufficed for you to be able to make some sort of judgment about it?
Well, not necessarily judgment, because I don't pass judgments. Some interpretation, if there is something of relative to potential heart failure or some type of significant anatomic finding, but certainly that would have entailed then combination with extensive sampling of the photographed area.
Okay. But am I to understand that you didn't receive any photos of Elijah McClain's heart?
Now, I don't remember. I might have received one photograph, but not any extensive documentation there. And this did not create any opportunity to define that there was an aberrant or atretic or narrowed left anterior descending coronary artery.
Did you go to Dr. Sina's office to view the stock jar of samples he has?
No, sir. I arrived the day before yesterday, I think, and I did not. I know Dr. Sina personally. I consider him a friend and a colleague, but I did not. I did not find it necessary because I expected everything to be in already.
So the answer to my question was no, you didn't go.
Absolutely no, I didn't go. Yeah.
Instead, yesterday, you sat right back there and watched Dr. Mitchell's testimony, right?
That's what they asked me to do.
You didn't take any of your own slides related to any of Elijah McClain's tissue samples, did you?
No, sir.
You're aware that both Dr. Mitchell and Dr. Sina did that, right?
Yes.
Now, when I was looking at your report, I didn't see listed that you had reviewed the security cam footage from the Shell gas station. Is that correct?
I included it under multiple, but I saw it. Obviously, I saw it first because it was the first of those body cameras segments. It was one from the Shell station.
Okay. So at least yesterday when you were watching Dr. Mitchell's testimony, you saw the Shell gas station video of Mr. McClain buying his iced tea.
No, I didn't. I couldn't see it from there. I was just sitting there. I couldn't see anything on the screen, sir.
Okay.
But I saw it several months ago.
All right. So you did see it before writing your report.
Yes.
Now, how about Elijah McClain's clothing? Were you able to see photos of his clothing before you wrote your report?
Yeah, he had dark clothes as depicted on the Shell station video surveillance.
Now, just a brief note about your compensation, Doctor. It sounds like as part of your work on your case, you were fairly compensated like most experts are.
I'm sorry?
It sounds like you were compensated in this case like most experts are.
No, I'm not. There is a different setup in our environment, and I am on my county time, my county government time, and they will submit their bill to the attorneys that engage me in this. I don't get a penny from this.
Oh, okay. So the county lets you do.
Oh, yeah. Oh, yeah, because they get compensated for the 8 working hours in a given day that I'm supposed to sit in my office and do my work.
Okay. Do you know the approximate number of hours that you worked on this case?
They keep the track of that, but I think it was between 35 and 40 hours altogether.
Now, Doctor, when I was reading your report, the tone of it makes it sound almost like you are upset with Dr. Mitchell. Is that accurate?
No, I am not upset with Dr. Mitchell. I respect Dr. Mitchell. He's a fine medical professional. I was just looking at the records and.
So, Doctor, the answer to my question is you were not upset with Dr. Mitchell?
Oh, no, I'm not upset with Dr. Mitchell.
In your report, though, you do dismiss his opinion as, quote, off the cuff. Is that fair?
The opinion about the manner of death, yes. Because if I can explain, because it was not substantiated by anything in his report or in his testimony.
But now,
It's-
Doctor, I understand that they're going to have some chance to come back and ask you some more questions, that you disagree with his manner of death. But when you say his opinion was off the cuff, you're aware that he has spent more than twice as many hours working on this case as you, right?
Yes, I am aware of that, but it doesn't make any difference. I stand by my statement.
And despite the fact that he reviewed more information than you still consider his opinion off the cuff. You stand by that.
Your Honor, foundation as to the amount of material reviewed in comparison. It's in testimony.
Response.
I can rephrase to clarify it.
All right, sustained in part.
So, Doctor, even knowing that he spent more than twice as much time as you on this case, you still stand by your opinion that you think his opinion is off the cuff.
His specific opinion about the manner of death, not, I agree on most of his comments and findings, but not about the manner of death.
Okay. Now, when you refer to Dr. Sina in your report, you twice call him the good Dr. Sina. Is that accurate?
Yeah, it is. It is there, yes.
Yes. But when you refer to Dr. Mitchell, you just refer to him as Dr. Mitchell, right?
I don't know Dr. Mitchell personally. I know that Dr. Sina is a good man and a good doctor. So that's the difference. I never met, I only saw Dr. Mitchell for the first time in my life yesterday. I wanted to catch him and talk to him, but he went away fast.
So, Doctor, I'm sorry, I'm not asking for the entire history of your relationship with both of them. My question was just, in your report, you simply refer to Dr. Mitchell as Dr. Mitchell.
Yeah, I think that suffices.
And in your report, you take issue with how Dr. Mitchell describes the basic facts about Elijah McClain before his encounter with the police, right?
Yes.
And you think that how a forensic pathologist describes the initial facts of a case can reveal whether the forensic pathologist has a bias.
Well, that may be the case. There may be a cognitive bias that comes to all of us, and we have to fight that away.
Absolutely. It can happen to anybody, all of us even.
Yes.
But specifically, you believe that looking at somebody's initial factual statement can help reveal if they have a bias.
Objection asked to answer.
I'll allow them to answer.
Sure. Yeah, it's possible to infer that there may be a bias, and that can be discussed then directly, of course.
And you also believe that that initial factual description of a case can reveal whether a forensic pathologist is acting as an advocate for one side or the other.
Well, it's my impression. That's it.
And your impression is that somebody's initial factual description can help show if they're an advocate for one side or the other.
No. It's not only because of that. It's because there is a combination of things, and the fact that
Doctor, I'm sorry,
Yeah.
I'm not asking you about all the reasons you might think somebody is an advocate. I am asking you specifically about your view on somebody's initial factual description of a case.
And I
You believe,
By my count, that's the third time that Mr. Slaughter has interrupted doctor's answer, and I'm going to ask the court to advise him to let the witness finish his answer.
Well, I'm going to advise the witness also to just answer the question of counsel.
Thank you.
So my question is just specifically with regards to how a forensic pathologist provides their original factual case summary. Just looking at that one thing, you think that that can show whether somebody is an advocate for one side or the other instead of being fair and unbiased?
That may be the case.
Now, specifically, you think that Dr. Mitchell's sentence about the basic facts of this case show that he has just such a bias and is an advocate, right?
I don't know about that, but if you should have explored that earlier when he was here.
So, Doctor, I just want to confirm your sworn testimony to the jury is that you don't know about whether you personally believe that his opening sentence shows he is biased or an advocate?
Yeah, you put those two things together from my report. My report is there on the record. So I have no further comment on that, sir.
So in your report, you say, regardless of the advocacy efforts reflected in the case summary of Dr. Mitchell's report, where it is quoted, according to the records and video footage from August 24th, 2019, Elijah McClain, a 23-year-old man, was walking home from a nearby convenience store when he was approached by two law enforcement officers. This is contrary to what is actually observed in the videotapes from body cams. You think that that sentence from him shows he is biased and an advocate?
I did not make that conclusion. I made that inference, and I was basing it against the impression that I had from viewing the body cameras.
Well, I'm glad you mentioned that again, Doctor. You're one step ahead of me because I want to talk about that. So here's the sentence from Dr. Mitchell's report that you just said represented those advocacy effects. You also say in your report that this sentence from Dr. Mitchell is a confabulation. Is that correct?
This confabulation is somewhere else, I believe, in my report. So
can we please show to the witness page 3 of his report? The last paragraph. Now, in your report, if you look at the third line there, you've got that direct quote from Dr. Mitchell.
yes, I see.
Yes, I reproduced that quote perfectly on this sheet, right?
Yes.
Now, after quoting that, you say, this is contrary to what is actually observed in the videotapes from body cams. This representation insinuates that Mr. McClain was inconspicuously walking home when he was stopped by the Aurora Police Department officers for no good reason. The question remains about additional video documentation that could support this confabulation. This is the confabulation you are referring to, right?
Well, I needed additional, I was questioning if there was actually additional video footage that could confirm this, because I was in disagreement with the account after viewing with my eyes the video footage.
Now, Doctor, a confabulation means, the National Institute of Health defines it as a neuropsychiatric disorder where a patient generates a false memory. That's a confabulation, right?
Confabulation is something that is concocted in someone's imagination, but it can have various meanings in many dictionaries. The Latin origin is for the concocted, preconceived idea about something.
Okay, a concocted or preconceived idea about something. Yeah. Now, I want to talk about this sentence that you described in your report. Now, the first part of this is just according to records and video footage from August 24th of 2019. You would agree that Dr. Mitchell did review records and video footage from August 24th, 2019, right?
Yes, sir.
The next words of the sentence are Elijah McClain. Dr. Mitchell got the right person who got killed here, right?
Yes.
Elijah McClain was a 23-year-old man. Dr. Mitchell got that right.
Sure, I have no issue with that.
Dr. Mitchell next says that Mr. McClain was walking home from a nearby convenience store. That is, in fact, what Mr. McClain was doing.
Yes,
So he got that right too.
yes.
And then Dr. Mitchell says when he was approached by two law enforcement officers. And in fact, that is what happened, right?
Yes.
So, doctor, it's fair to say that this sentence that you describe as a confabulation is in fact completely factually accurate.
Well, it is factually accurate,
Okay.
but missing the prequel and not mentioning that prequel.
Well, let's talk about another factual recitation, doctor. Let's talk about yours. Now, doctor, in your report, in your factual recitation, you say that at the time it was reported, Mr. McClain had a dark ski-type mask on his face. That's accurate, right?
Yes, that's what I learned.
But then you say he was clad in a heavy winter coat.
That was reported. I did not see. This was reported in the reports. Yeah.
And so, doctor, are you saying that you are basing that just on the reports from the people involved here that it was a heavy winter coat?
No, in the reports that I reviewed, sir, and I could not discern what exactly the type of the jacket was because I could barely see Mr. McClain during the confrontation on those footages.
So, doctor, you could barely discern Mr. McClain and what he was wearing.
What he was wearing, yeah.
You didn't write, I'm not sure what he was wearing. I can barely discern it. Instead, you wrote, he was wearing a heavy winter coat. Is that accurate?
That is accurate based on the Shell station video.
You chose those words because heavy winter coat makes it seem more bizarre what Mr. McClain was doing that day, right?
I cannot explain the behavior, but I had that information and I put it on.
Doctor, I'm not asking you to explain Mr. McClain's behavior. I'm asking you to explain yours. Why did you choose those words, heavy winter coat, instead of the truth that you can't tell what kind of coat he was wearing?
Objection, that's improper argument in.
Sustained.
Now, doctor, the next thing you say is that Mr. McClain was wandering toward the traffic. Now, when we see Mr. McClain first approached by those officers, he's just walking on the sidewalk, right?
Yes, but before that, there was a report, 911, that he was walking toward the traffic.
Doctor, that 911 report says there is a guy walking south on Billings Street, not there is a guy wandering into traffic, right?
Object, and the doctor has provided testimonies of the 911, and if counsel wants to open the door to witnesses they haven't brought forward and what they testified to in other proceedings, we can go down this path, but
Well, Your Honor, also reject this argument in facts, not evidence.
The 911 call is in evidence.
And it speaks for itself.
Well, this is cross-examination as well, so the court will allow it.
So let's show to the witness the transcript of said 911 call that is in evidence. Bates page 33792. Now, if you look on the middle of the page there, sir, there's the statement, okay, tell me exactly what happened. And the 911 caller says, so there's a guy. He's walking, let's see, south? What's the opposite of north? And the 911 dispatcher says south. The caller says south. Yeah, he's walking south on Billing Street and he has a mask on. You would agree with me, sir, that there is no reference in that 911 call to anybody wandering toward the traffic.
There is no reference to it in this. I gleaned the information that obviously I read from the materials that I was sent. This is not something that I pulled out of nowhere. And I saw that he had a dark jacket in the Shell Station video.
You anticipate my question once again, doctor. If you didn't pull it from the 911 call, then where did you generate this memory of somebody wandering into traffic from?
From some information there. I can't remember off the top of my head.
Is it possible you confabulated it?
I tried not to imagine things. I tried to put the things together as they are somewhere in some reports. So how would I come to the idea that he was walking into the traffic or toward the traffic without someone saying that or someone writing that in the report?
But suffice to say, you don't know who said that or where that is.
I do not know who said that. No.
Thank you, doctor. That's all the questions I have for you.
Redirect.
Yes, if I could have just a moment, Your Honor.
We can take that down.
Let me start with a few questions, doctor.
No, why don't we wait just a second until
Jerry,
get our refreshments passed out or the water.
that while I look at this.
And whenever you're ready.
Doctor, you've read a lot of records with respect to this case, correct?
That's correct.
And are you coming here with any bias for any side, one side or the other?
No, ma'am.
Are you trying to tell this jury what you believe occurred? It's foundational, Your Honor.
Well, it wasn't leading. He could have said no or yes.
Go ahead.
Can you repeat the question, please?
Are you trying to tell this jury what you believe happened with Mr. McClain?
I hope I just did over the past couple of hours.
Okay. And while we look for some specific things, I want to talk to you about a couple things. With respect to the heart, if you saw a photo of kind of just the organ, is that what you expect when you're trying to figure out what's going on with the heart?
Well, obviously that wouldn't be sufficient for exploration of something of significance that has been reported. And that should have been documented a little bit in more detail photographically and otherwise.
So fair to say, if you're looking for some issue with an internal artery of the heart, you need to cut the heart open or at
Well-
least dissect it.
Well, you need to explore all views of the heart to see the surface because coronary arteries run on the surface of the heart and then sample the areas, geographic areas of supply because each coronary vessel supplies certain area. And in that situation, that should have been sampled and demonstrated in extent or and concluded whether there is a problem or not, there is no problem.
And if you think you see a problem, you think you'd take a photo of that area.
That's the usual thing that things are done, but I can't comment any further.
Similarly, you were asked about recutting slides. Did you receive slides in this case?
Yes,
So are those taken from tissue samples from the organs that are preserved?
yes, from those that were not harvested. Yes.
Okay. Can you give the jurors an idea of the size of the sample?
Okay, the tissue sample, when it's taken from any internal organ or even the surface of the skin or the head or the brain, would be about 3/4 of an inch by 1/2 an inch, and then embedded in paraffin block, as we talked about earlier, and then very thin, couple of microns slices are cut out and mounted on a glass slide and stained with the standard stain that histology provides. This is hematoxylin stain. So then their cover slip and that material is placed under the microscope and viewed. So it is a pretty small piece from a relatively sizable organ when we are talking about heart or the brain. Of course, some other small organs like pineal gland or pituitary gland can be sectioned as a whole and presented on a slide. But that's the limitation of exploration or diagnostic workup on the slide.
Remember, you were asked some questions about whether or not if somebody has been sedated with ketamine and it would prevent their breathing and their inability to clear some substance. Do you remember that line of questioning?
That was the general questioning. I don't remember that it was specific to this matter as pointed by the gentleman that put the question forward.
And your answer was, I don't believe that's applicable to this setting, but then you were cut off. Judge, I think that the doctor can be allowed to answer the question that he was cut off from answering on cross.
I'm sustaining the objection.
Let me ask this, doctor. Do you believe that ketamine caused Mr. McClain to stop breathing? Judge, they went into breathing, respiration, respiratory arrest, and ketamine.
She wants to ask any general questions about those things. That is fine. Any questions? His opinion.
Give me a second. Well, the court will note that there were questions asked concerning the effect on a sedative or ketamine upon one's ability to potentially expel materials that were inhaled. So the court will allow brief inquiry into that and with respect to aspiration.
Sure. Go ahead, doctor. Do you think that the ketamine in any way, shape, or form impacted Elijah's breathing?
I agree. That was beyond what the court allowed.
What is your opinion as to whether or not in this situation, Elijah's breathing, what impacted his breathing? I didn't say ketamine, Judge. I said breathing, and there was plenty of questions about that.
She wants to follow up.
Sustain.
Prior to receiving ketamine, did you notice Mr. McClain struggling with breathing?
Yes, ma'am.
And can you explain to the jury how that informed your opinion?
Well, there was clearly grunting and gurgling on the part of Mr. McClain during the process while he was being held by the officers, and he also vomited at the time, and well, he inhaled and had impairment of his breathing.
So how can somebody be vomiting due to ketamine before they receive ketamine?
People can vomit for various reasons. Mr. McClain vomited not because of ketamine being administered to him. He vomited because of the pressure on his body and displacement of his stomach contents that came up and got inhaled. That was what was impaired his breathing, among other things. His breathing was also impaired by the being restrained by the officers.
Fair to say that when he was wearing the mask and vomiting, ketamine wasn't even on scene.
Yeah, that was early on in that segment of 14 minutes.
And during the times he was vomiting with law enforcement on scene before fire even arrived, ketamine wasn't on scene. Judge, it
Oh, I'll allow him to ask with respect to the question with respect to his observations. But
that's as far as
also,
yeah,
also is leading.
certainly. With respect to your opinion, the vomiting that occurs with law enforcement before fire is even on scene and ketamine is even on scene.
No, ketamine came toward the end of the whole process.
If I can have shown to the witness only, and it's going to be date stamps, if I'm reading this correctly, S-197 initially. And if I can direct you to lines 19 through 25, if you can read this to yourself. And then if we could go to pages 201 and 202. Again, zoom in. On lines, I believe it's 53, no, 19.
23 on.
23 on. So, Dr. Dragovich, is this refreshing your memory as to where you got information about Mr. McClain and how he was acting prior to law enforcement? Judge, it absolutely does.
I don't know what it says.
Correct. So I'm going to let the doctor, if we can ask him.
You can ask him if it refreshes his recollection. But
Is
not,
this-
not the specifics.
Certainly. Did you have time to read it?
Yes.
And does that help refresh your recollection as to what informed your opinion about the caller and why Mr. McClain was reported as wandering towards traffic?
All right, I suppose a little foundation would be helpful.
Doctor, you said you received a large external hard drive, correct? Can you estimate for the jury how much material was on that external hard drive?
It was a lot. I mean, I can't be very specific because I don't have it here with me. But there was a lot of information, a lot of statements, a lot of transcripts, a lot of basic stuff, the video from body cameras, and you know, when you go through it, you pick up certain things and make a note of it, and that's how a report is generated.
Correct.
The
And-
report is as accurate as I believe is accurate based on the materials that I reviewed.
And
That's it.
are these what you're looking at when you're referencing reports and statements? Is that what you're talking about?
But that's the kind of thing. And I certainly could not mark the particular page, but it's there in that material.
Right. And what we're looking at, is it fair to say this is reports of the 911 caller?
Yes.
And can you tell the jury,
Sustained.
Doctor, in reviewing and refreshing your memory, how does that relate to what you reported in your report to the jury?
Sustained.
Doctor, I believe I just asked you, have you seen these reports before?
Obviously, I have seen it because those would be the sources that allowed me to put what I put in my.
Did you delineate every single page of report, statement, and discovery you reviewed prior to writing your report?
Oh, man.
Were you under a time crunch to get your report in?
From your end, yes, I mean, but because there was a short notice to review the materials before I left the country.
And do you recall now, after reading this, that this was the information or information like this that you had, Judge, it's foundational.
He has testified, he reviewed it.
She asked him an open-ended question, how big you tell it.
The court will find that there's been adequate foundation laid, but we're not going to get into the specifics of the what's said in the document.
Doctor, in reviewing what you've already reviewed, does it inform what you were talking about in your opinion? How so?
What I reviewed, I reflected in my opinion, what included my opinion, my best belief about what I perceive, and that's it. And I signed that report.
And what you just re-reviewed, is that consistent with what was in your opinion?
Sustained, and one's own consistency is not for that witness to determine.
And Judge, I'm trying to not ask specifics about what's being said, so if I could have a little latitude, that's all I'm trying to do.
Very little.
Thank you.
Judge, I would also ask this be taken into consideration for the purposes of testifying.
That's fine.
That's fine. Doctor, you were getting ready to say this informed re-reviewing what you've already seen, how it informed your opinion and the statements that counsel directed you to. Did that help you refresh your memory about where you got information?
It does, and it might be another source as well addressing this. But since I did not index it in the report that gives the overview of my findings and my opinion, that's it.
And was what you just re-reviewed consistent with what you wrote in your statement?
Sustained.
Doctor, in your opinion, what you just re-reviewed, how does that conform with what was in your statement?
Sustained once again.
Doctor, is there anything additional from reviewing that discovery that you would like this jury to know?
I don't think so.
And does it in any way, shape, or form change what was in your opinion?
Overall.
Go ahead.
No, it does not.
Okay. I could have just a moment. Thank you, doctor. I really appreciate it.
You're welcome, ma'am.
Have a good afternoon.
You too.
Redirect on behalf of Mr. Cichuniec.
Just brief redirect, Your Honor. Dr. Dragovich, when you were being asked questions by the prosecution, I believe you were asked a question about whether or not someone who was sedated, whether or not they could breathe on their own. Do you recall that line of questioning from the prosecution?
Yes, sir.
And I believe your response was in theory, but not applicable here. And then the prosecutor cut you off. Do you recall that?
Yes.
Okay. What was the rest of your answer when the prosecution asked you whether someone?
Sustained. I sustained that same question just a few minutes ago. Next question.
Okay. Well, doctor, let me ask you the same question the prosecutor asked you. Is it possible with someone who is sedated, whether or not that can impact their ability to breathe?
Anything's possible. And it can happen or it cannot happen. It depends on various circumstances, because you're asking a general question that was posed as a general question, and I have to answer it with a caveat that there is a myriad of things, a spectrum of things that will influence that particular happening in any individual. So that's where I turn to the specific.
So based on your review of the material in this case, and predominantly the body-worn camera video in this case, did you see anything on the video after Mr. McClain had been administered ketamine that concerned you about his ability to breathe?
Objection beyond the scope.
Well, this isn't beyond the scope because this is what I believe was inferred by the prosecutor's question. So I think I can inquire as to whether or not this influences his opinion, whether or not he saw anything of that nature.
Well, the prosecution asked a general question and received an answer that they didn't ask for. So the objection is sustained.
Doctor, you were asked on cross-examination whether or not you had made any additional new slides based on your review of this case. Do you recall that?
Yes, sir.
Okay. And you did not request any additional slides, correct?
No, sir.
Okay. But were you able to review the slides that Dr. Sina requested during his initial autopsy and additional slides that were requested by Dr. Mitchell?
I believe so. I was sent microscopic slides that were pertaining to the case.
Okay. And so you were able to review the slides prepared in this case?
I did review them. That's indexed in my opinion.
You were asked some questions about whether or not you were upset with Dr. Mitchell. Do you recall that?
Yeah, I recall that. I had no reason to be upset with
Okay.
Dr. Mitchell.
Is it possible to disagree with a colleague without being upset with them?
Of course.
Okay. And with respect to manner of death, do you disagree with Dr. Mitchell?
Absolutely.
Nothing further. Thank you, Your Honor.
May the witness be excused.
Yes, sir.
All right, you may step down. Thank you.
Thank you, Your Honor.
We're going to have counsel approach. Next witness for the defense. If you'll step up here to my right and around the glass panels, and I'll swear you in.
After you, Judge.
For the testimony you're about to give.
Yes.
You'll please be seated. Once you're comfortably seated, if you'll please speak somewhat loudly and or close to the microphone. Tell us your name and spell your last name.
Sorry, Judge, I did not hear you.
If you just want to tell us your name and then spell your last name for the record, please.
My first name is Gary, and my last name is Ludwig, Ludwig.
Your witness.
Yeah, I briefly approached the witness to give him a bottle of water.
Sure.
Thank you. Appreciate it.
Good afternoon, sir.
Good afternoon.
Could I have you start by introducing yourself to the jury?
Sure. Good afternoon. My name is Gary Ludwig, and I come from just south of St. Louis, Missouri. I live in a small community called Hillsborough, Missouri.
And how are you currently employed, Mr. Ludwig?
I work for the local community college where I live at. It's Jefferson County Community College. I work as an EMS educator where I teach EMTs and paramedics
How long have you yourself been a paramedic?
I've been a paramedic for 44 years, and I've been in the profession for 46 years.
And where did you start out as a paramedic?
Well, I started employment with St. Louis originally, and then after about, I guess, a year and a half or so of employment, I went to paramedic school. So I became a paramedic while I was employed with the city of St. Louis.
Do you know what year that was?
I think it was 1979, I believe.
And did you progress through, well, first of all, who are you working for in St. Louis?
The St. Louis Fire Department.
Did you progress through the fire department and rise through the ranks there?
I did, yes.
And can you tell us about what your assignments were while you were in the St. Louis Fire Department?
Well, I was originally hired as a, what they call a PSC or public service employee. It was a federally funded program where they put you through the fire academy and you worked on fire trucks and you worked on ambulances. And then an opening came on the EMS side, so I applied for that, accepted that position. And then I rose to the rank of paramedic captain. And then I became a deputy chief over EMS, and then eventually the chief paramedic of the fire department.
Would it be fair to characterize you as a fire medic when you were working in St. Louis?
You could. That wasn't a terminology that was used there, but, I had credentials as a firefighter, and I was also a licensed paramedic in the state of Missouri, yes.
And you said that you became a paramedic captain. Is that fair to say?
Yes.
How long did you have that position?
I believe it was about 6 years.
Did you have any teaching responsibilities in that position?
Yeah, it was not only supervision, but one of my roles was obviously we hired individuals who were relatively new to the profession. And so they were, I don't want to use the word green, but they were inexperienced. And so there was opportunities to teach, to learn, to give them my wisdom, my knowledge of different situations. And that's what we do in this profession. We are always developing those that come up behind us.
And in the St. Louis Fire Department, did you operate under protocols?
Yes, we had medical protocols, yes, made out, and they were set forth by the medical director.
The medical director for the St. Louis Fire Department?
Yes.
In your responsibilities in St. Louis, specifically your teaching responsibility, did you teach the importance of following protocols?
Absolutely, yes. That is our directive. That is our guidelines. That is, what we set forth and what we use to treat patients with.
When you were a captain in St. Louis, did you continue to go out on calls for the fire department?
Yes, I had one half of the city, and another paramedic captain had the other half of the city. So there were always two of us on duty on every shift. And so I not be repetitive, but I had one half of the city, yes.
And when
And I would respond to calls, of course.
And what kind of calls would you respond to?
Oh, they ran the gamut. Obviously fire calls, but the majority of what fire departments do are EMS calls. I like to say that we're a fire department is really just an EMS agency that sometimes goes to a fire call. If you look at most fire departments, probably anywhere from 65 to 90% of their calls are EMS related. So the majority of my calls that I went on were EMS related calls, and they varied from medical to trauma calls. And they ran the whole gamut. We, St. Louis is a busy urban city, and there were many calls in trauma when we talk about shootings, when we talk about auto accidents, medical when we talk about heart attacks, strokes, behavioral patients. So it ran the entire gamut.
You said that you were then promoted to deputy chief, is that right?
Yes.
Did you continue teaching in that capacity?
Yes, I continue teaching in that capacity, yes.
Specifically teaching paramedics?
I specifically teach in paramedics, and And some of it was formalized. Sometimes I would teach a class. The training officer would ask me to teach a class. And other times you take the opportunity to coach or mentor or, again, try to develop those that are coming up behind you.
How about going out on calls? Did you continue to do that?
I still continue to go out on calls. Yes, I was still an operations chief.
How long were you employed at the St. Louis Fire Department?
25 years.
When you left St. Louis, did you go to another large urban center?
Actually, I retired and went to Jefferson County, Missouri, where I currently live at. I became the director of emergency services for that county. And then I took a job with a private 500 corporation. I got a job offer. And then I became the director of a paramedic program. And then I was recruited, and I think that's where you're going, is to the Memphis Fire Department. I was recruited to the Memphis Fire Department, where I spent about 10 years down there.
And what years were that?
It was 2005 to 2014.
And in what capacity did you work with the Memphis Fire Department?
I was hired as a deputy chief, and my role was specifically to rebuild their EMS system. It's a busy system that does about 125,000 to 140,000 runs a year, has 1,800 firefighters, and they had neglected the EMS system for many years. It had significant challenges to the system, and I was recruited to come down there and help rebuild that system.
Did that involve continued teaching as well?
Some of it was teaching. I taught some classes, although I did have a bunch of instructors out at the fire academy, and that was their main role, was to do the EMS education. But I would be calling in occasionally to teach some classes, yes.
Okay. Were you involved in any capacity with developing the protocols or developing what would be taught to the paramedics?
Yes. I was involved in not only St. Louis, but also in Memphis with helping to develop protocols. Although I am not the one that can issue them or the one to approve them, that comes from the medical director. But I specifically would help develop those, and in some cases, virtually write the entire protocol for the director, the medical director, to either edit or change or whatever. Or in some cases, just he would accept what I had forwarded to him, and it was approved. And then we would have to train the paramedics on that protocol.
And you said you were with Memphis Fire from 2005 to about 2014. Was that your testimony?
That's correct, yes.
9-10 years approximately?
That's correct, yes.
Did your employment continue as you've described for that 9 or 10 years?
Yes, I was an operations chief, so not only did I handle the administrative side of things, but I frequently respond to calls. Again, it's a busy system, and I'm virtually going on calls every day. There's bus crashes, there's multiple alarm fires, there's multi-casualty events. There's always something happening in a large city.
Including, as you described in St. Louis, medical and trauma calls?
Yes, correct, yes. I would just say it's not something to be proud of, but St. Louis and Memphis always rank high on the list with the FBI as some of the most violent cities in America, unfortunately.
And then were you also employed in Champaign, Illinois with the fire department there?
Yes, I served as the fire chief there for 8.5 years.
Are you able to estimate how many medical related calls you have been in your career, Mr. Ludwig? Any idea?
Yes, a conservative estimation is about 35,000 runs that I've made during my career. And again, that's over a 46-year career. And again, these are busy urban EMS systems where you are making sometimes anywhere from 5 up to 16, 18 runs a day. So if you multiply that, that's over 1,000 a year. And if you take that to its logical conclusion, you're talking about, again, after 46 years, I estimate conservatively over 35,000 runs in my time.
Were you affiliated with the EMS section of the International Association of Fire Chiefs?
I was. I served on the executive board with the International Association of Fire Chiefs for 22 years, and I was chair of the section for 6 years. And that board specifically helped develop policy at the national level for dealing with fire-based EMS.
Are you still a licensed paramedic today?
I am. I'm licensed in Illinois and in Missouri.
Have you written on the subject of paramedics and protocols in care of patients?
I've written extensively. I have to go back and look at all the articles I've written, but I have written over 500 articles that have appeared in our periodicals or in our professional journals, like Firehouse Magazine, EMS World, Journal of Emergency Medical Service, Fire Engineering. I can go through the list of them, but I've written over 500 columns for those various publications.
All right. Your Honor, at this time, I'm going to move to qualify Mr. Ludwig as an expert in paramedic, specifically fire department paramedic training, protocols, roles, and responsibilities in a pre-hospital setting.
Board order.
Now, Mr. Ludwig, you've never worked in Colorado, is that right?
That is correct, sir, yes.
So your familiarity with the Aurora Fire Department's protocols comes purely from your review in this case?
That is correct. I reviewed them, and I would also say that I have looked at, again, I worked in 3 different departments that had protocols. I've done consulting for countless fire departments that have protocols. And I would add that in my capacity as an expert over the last 20 years, that I've also looked at a myriad of different types of protocols. So it's not only, this was not my first shot looking at protocols. I just want to amplify that.
And Mr. Ludwig, I appreciate your desire to want to amplify things, but my question was simply, your only review of the AFR protocols was from your interaction in this case, right?
Yes, sir.
That's all I've got for you. Thanks. Judge, I'm sorry, I didn't write down exactly what the qualification is, so I'm not sure if I object.
All right. I, quite frankly, was not fast enough either.
Paramedic, specifically fire department paramedic training, protocols, roles, and responsibilities in a pre-hospital setting.
All right.
Thank you. Mr. Ludwig,
Well, no, I just wanted
Oh.
to give, that's okay. I just wanted to give Mr. Slaughter a chance to absorb all of that as well.
The disclosed endorsement was for fire medic training, roles, and responsibilities in skills setting.
Okay, that was the endorsement. The court will allow the witness to opine as well as explain in those areas.
Mr. Ludwig, as Mr. Slothauer kind of alluded to, you were contacted by Shauna Bagan, correct? Attorney for Mr. Cooper?
Yes, I believe the sequence of what occurred was they reached out to a,
We don't need to go through the. whole
okay,
sequence. Ultimately, you were contacted by me and Ms. Bagan on behalf of Mr. Cooper, correct?
yes,
And we asked you to undertake a review of the Elijah McClain case. Is that right?
yes, sir.
Is it fair to say you reviewed a great deal of material in connection with your investigation into this case?
Yes, there was an extensive amount of material that I reviewed, yes.
Are you able to say at this point what all of that was?
I can read that from my report if you wish, but again, that's however you wish me to proceed.
Am I right In your report, you lay out basically 77 separate pieces of information.
May I look at my report?
Would that refresh your recollection?
Yes, I don't have that number memorized. Is it okay, Judge, if I look at my report?
You may, if it refreshes your recollection.
Thank you. Yes, 77.
That included, among other things, body-worn cameras. Is that right?
That's correct.
That included files from the coroner's office. Is that right?
That's correct, yes.
A number of transcripts of various people's testimony in court. Do you review those?
Yes, I did.
Was it your understanding you got, let me rephrase the question. From looking at all the records you reviewed and the body-worn cameras, were you able to determine who the people were in the body-worn cameras?
I was able to determine who the firefighters were. I didn't specifically look at and try to identify who the police officers were. Although I could draw some conclusions because I know who the first 3 officers were on the scene from those cameras. I don't know who was specifically who, so other than the first officer who made contact.
Did you review interviews, transcripts of interviews that were done with police officers that were at the scene?
I did, yes.
And did you review testimonies or reports of all of the paramedics or EMTs who were at the scene, both from Aurora Fire and Rescue and from Falk Ambulance?
I did, that's correct, yes.
Did you review medical records for Elijah McClain as well?
I did. The patient care report that was generated by Falk and Aurora Fire and also the hospital records.
And have you reviewed the reports and testimony from various experts for the prosecution, including Dr. Buther, Dr. Mitchell, Dr. Robinson, and Dr. Sina?
Yes, that is correct, yes.
You have a part of your report where you lay out parties involved in the incident, is that right?
Yes.
And what I was getting at with your review of the body-worn cameras and all of the reports, from your review of those, you were able to put together kind of a list of everybody who was involved in this scene. Is that fair to say?
That is correct. If I could just expand a little bit, yeah, I believe there was 8 different video cameras, and then I received a total of 42 different video clips.
Did you also review Aurora Fire and Rescue protocols that were in effect in the summer of 2019?
I did. Yes, that's correct.
I want to start by talking to you about coming to a scene. Do you always know when you go to a scene what's going to be happening once you get there?
No, I can tell you, based on my experience, we don't ever truly know what we're walking into. And this was evident here. They got dispatched for one thing, and when they got there, they found something else. And a lot of times we don't get a lot of information from the dispatchers of what's going on, because sometimes they don't get all the information. So I can tell you that we walk into situations not knowing exactly what we're going to see. And we have to rapidly assess what's going on, because again, a lot of these are life and death situations.
Response?
I think it's responsive, but it may be a narrative. I'm happy to ask another question.
Yeah, that goes, I suppose, beyond responsive. So next question.
When you go to a scene, Mr. Ludwig, is there a concern for safety of paramedics?
Absolutely.
Have you specifically taught paramedics on the importance of safety to paramedics at a scene?
Search relevance is totally not. Other paramedics and assistants.
Response.
Judge, he's been qualified as an expert in the training, and this is asking him about his own experience in training.
All right. Based upon the form of the question, the court will sustain it.
What are the concerns when you go to a scene?
Our first priority, what we're taught, is scene safety, not only for us, but for our crew and also for the patient.
Why is safety for paramedics an important concern? Wasn't it just the safety of your patient the only concern?
Well, as I like to say, victims cannot rescue victims. So if you're hurt or have you've been in some way not able to help your victim, obviously the victim suffers then also. So it's so important that your safety is maintained so that you can help your victim. And that's the key reason. And I will tell you that over time, there are studies that reflect the number of firefighters who have been injured. I have worked for the federal government on a NIOSH case where a fire.
Let me cut you off
Okay.
and ask you a question about that. Are you referring to a 2016 study that you reference in your report?
Yes, the Drexel University study.
And what were you referring to in that regard?
So the university did a study, and the acronym is FIRST, and I'm trying to remember what that acronym stands for. I think it's firefighter injury. It's in my report. But basically, we know firefighters and medics were being injured. We just didn't know the extent of what they were being injured. And so Drexel University did a study, and they found out that firefighters are subject to get injured 14 times greater on medical calls than firefighters who don't go on medical calls. And they actually think that number was low because a lot of firefighters, they surmise, they just basically accept it as part of the job.
The Aurora protocols address scene safety as well.
They do. In fact, I did a search for the word safety in the protocols, and it comes up 16 times, mostly in the behavioral health, agitated patient, combative patient protocols.
Have you gone to scenes and dealt yourself personally with agitated patients?
Yes, quite a few. Again, if you,
You testified about approximately 35,000 calls in your career. Any idea at all how many of those involved agitated patients?
So if you look at the studies, suburbia, about 5% of, I'm sorry,
All right, well, I'll just ask the witness.
I'm sorry.
You need to listen carefully to the question that the attorney asks and just answer that question. And if the attorneys need elaboration, they will ask you for it.
Sure, Judge.
Right now, Mr. Ludwig, I'm asking you specifically about your experience. You testified you've been out on about 35,000 calls, is that right?
Yes, sir.
And I'm asking you if you can approximate, if you can, how many of those calls involved agitated patients?
I estimate hundreds, if not thousands of patients.
The word agitated, is that a pretty subjective term?
Yes, it's very subjective, yes.
Is part of a paramedic's responsibility to determine if a particular patient is agitated or not?
Yes, that is part of our assessment process of determining what is happening with the patient, yes.
And in your review of the Aurora protocols from 2019, are there efforts to address what constitutes an agitated patient?
Yes, there are some descriptors in there, yes.
Can that be spelled out for every situation a paramedic might encounter?
No, that's not even possible. That's, no.
You talked about not knowing what might happen when you go to a scene. Is there a wide range of things you yourself have seen at scenes?
Yes, if I could elaborate. And again, I don't want to get off base, but I can elaborate on that. Yeah, I've seen the gamut. I can tell you that I have been kicked. I have been spat upon. I've been hit. I've had a weapon pointed at me. And I've actually been shot at before. It was, I can go back, I won't go through those details, but scene safety is part of, again, trying to prevent us from being injured. And I have experienced that. I can tell you that I actually dealt with a patient one time that we were trying to restrain. It was only one officer and myself.
Sustained. And I'll remind the witness, if the attorney asks for elaboration, they will ask for it.
I want to ask you this, Mr. Ludwig. Is it uncommon in your own experience going to calls that a patient, an agitated patient, can up and then down and then up again?
Overall,
You can answer it.
Okay. Yes, in fact, that is common, what we see with excited delirium patients. We have peaks and valleys where we have periods of manic and we have periods of calm. I actually had a patient pinky swear one time that they would be good, and
sustained.
I'm sorry, Judge, I
It's all right.
All
It's
right.
all right. So I want to ask you about, have you observed agitated patients who appear to be totally calm come back into a hostile manner again?
I'll allow it, but we need to try to move on. Go ahead.
You need me to re-ask it?
Go ahead.
You need me to re-ask it?
No, I will say yes. I'll just leave it at that.
You mentioned excited delirium. Have you dealt with that condition in your own experience?
I have, yes.
Have you observed regarding excited delirium, patients appear to be calm, then become antagonistic again?
I have, yes.
Is that uncommon?
No, it's not uncommon.
In talking about scene safety, does it make a difference if there are already police officers on a scene when you arrive?
Increase the scene safety, but that doesn't mean that scene is secure or it is safe.
And why is that?
Because scenes can still be fluid. And just because the police are there doesn't mean that the situation is secure.
I asked you earlier about patients becoming antagonistic towards you. Has that happened even when police officers have been present?
Yes, it has.
Is that rare or uncommon?
No, it's not uncommon.
Would you say that, well, let me rephrase that. In your experience, have you had patients you believe suffering from excited delirium have adverse health effects from that?
I'm trying to recall specifically, you talking about, can you detail adverse, what do you mean by adverse health effects? Could you?
Cardiac arrest?
Fortunately, I have not ever had that happen, or nor have I seen that happen, so fortunately. But I'm aware of it happening, yes.
Is excited delirium considered a medical emergency?
It is. It is a medical emergency. I can elaborate if you wish, but again, I don't want to
That's okay.
be out of order again.
Is it considered a life-threatening medical emergency?
It is. It is a life-threatening emergency, yes.
Our paramedics taught, specifically Aurora, their protocols of 2019 taught that without intervention, the patient could die.
Yes, I saw that in the training, yes.
Are there specific signs or symptoms that paramedics are taught and included in protocols to look for with excited delirium?
Yes, we are specifically taught to look for hyperaggression, someone who is abnormal amount of strength, someone who is not making sense, someone who's talking gibberish, someone who seems to be out of control, someone who is fighting, someone who is agitated. Those are all the things that we're looking for when we look for excited delirium in a patient.
Are there any medical signs that you look for in somebody or that you're taught in protocols to look for with excited delirium?
Yes. We use the word tachypnea, which means they're breathing fast. I can elaborate again, but I don't, again,
What
and also tachycardia, which means their heart is beating fast, but I can explain some of that, but again, I'll defer to you, so.
Okay. Tachypnea and tachycardia are two of the signs you look for, is that right?
On the medical side, yes.
About diaphoresis.
I'm sorry, you're correct, diaphoresis, yes, where they have profuse sweating going on. Diaphoresis, the skin may be very hot, hyperthermia of the skin, but again, the main signs are the fast breathing, the fast pulse, which makes sense, they're fighting, and also the diaphoresis, or the sweating, the profuse sweating.
When you are on a scene and is it unusual for police officers to get there before paramedics get there?
In some cases, that is correct, but in other cases, as I said, sometimes we don't know what we're walking into. You get dispatched for one thing, and next thing you know, you hear somebody calling on the radio to send the police right away because of what's going on at the scene. So it can go both ways.
How often would you say, in your own experience, you arrive at a scene and police are already there with someone who's supposed to become your patient?
Anecdotally, I would say probably about 65 to 75% of the time, you have police on the scene first.
Is it unusual to come to a scene and have no other bystanders, just police and your prospective patient there?
Yes, yes, that's correct. A lot of times, some of these calls occur inside a residence and there's no one else in there.
Is it unusual for a paramedic on a scene to rely on what police officers are telling them happened before they arrive?
Absolutely. That's part of our assessment process of what's going on.
Is it unusual?
Oh, I'm sorry. I thought you said, is it usual? I didn't hear you correctly.
Is it unusual for paramedics to rely on police officers' account of what happened before they arrive?
No, we rely on what they're telling us.
I want to talk to you about assessing a patient. All right. And I want to start with ABCs. What are the ABCs?
So the ABCs are airway, breathing, and circulation. We want to determine that the patient has an airway, that they're breathing, and they have actually circulation.
Can you, as a paramedic, determine somebody's ABCs without actually touching the patient?
Correct. I could look at you right now and tell you that your ABCs are good. You have an airway, you're talking to me, you're moving air. The fact that you're talking tells me that you're moving air past your vocal cords, so therefore you're breathing. And the fact that you have mentation, that you're talking articulately, or talking in an articulated manner, tells me you have brain function, so therefore you have circulation. So yes, I can look at you and tell that your ABCs are good.
You reviewed some of the things I didn't ask you about. You reviewed the Shell gas station surveillance video, is that right?
That's correct, yes.
And that basically shows Elijah McClain in line waiting to buy some items and paying for those items. Is that correct?
Yeah, I believe there was 2 videos I saw, yes.
Another video is him leaving the station and walking down the street. Is that right?
No, the 2 I saw were him inside the station.
Right.
That's the only ones I think I saw, yes.
And then did you see body worn cameras of the first encounter between he and police officers?
Yes, I did see that. I believe that was, I don't want to guess, but I think it was Woodard, I think. I'm not sure.
Woodyard?
Yes,
And you reviewed the other officers' body cameras who were present on scene as well. Is that fair to say?
I did, yes.
Is there a priority or a ranking that paramedics are taught when they arrive at a specific scene? An order of priority?
Correct. What we teach paramedics is scene safety first, and I'm going to say the word BSI. And what
What is BSI?
So BSI stands for body substance isolation. We want to make sure that, again, it's part of scene safety, it's part of our safety, that we're not getting or receiving, if the patient has that airborne disease or bloodborne disease, that we're wearing the proper gear. We're wearing our gloves. If they have an airborne problem, maybe tuberculosis, that we're wearing a mask. If there's blood that's splurting, that we actually have goggles on because the blood can get into our mucous membranes of our eyes. So you have to make sure that you have all your BSI. So the 2 priorities before the ABCs actually are scene safety and BSI. We drill that into paramedics continually.
Right. What's the second? I asked you about 3 priorities. What's the second priority?
The second one is what we just went through with the ABCs. So the first thing you want to do is you want to check and make sure that your patient has a patent airway, that they're breathing, and they have circulation.
Did you review as well body worn camera video footage prior to the arrival of Aurora Fire on the scene?
I did, and that's correct.
Do you know how long officers interacted with Mr. McClain before Aurora Fire arrived on scene?
I don't want to conjecture. Can I look at my report again?
Sure. That would refresh your recollection.
Yeah.
Please do.
I believe, and again, some of the camera times are out of sync,
Right.
but as best as I could reckon, I think they interacted with him about, hold on, stand by.
While the witness is checking things out, I'll just remind you, the court would like to break at about 10 till.
This is probably a good time if you want to do it now.
Okay.
Oh, I'll ask him.
All right, I just want to make sure the timing with my staff.
Okay.
I expect we could all make it back by 8:30? Okay, all right. Folks, we are going to take our break for the evening.